children singing songs, sliding, 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 sliding. People say, "What's up, slide? What's up, slime?" That's what's being criminalized. That's the overhead. The next one becomes lyrics. Now, I separated these to just group them together, but these are songs. Some of them Jeffrey performed, some of them he didn't perform these lyrics. Some of them, the lyrics got changed because he doesn't write them down. The prosecution did not have the lyric find them. They went out and they did a database. And they searched all of Jeffrey's Instagram, all of his Facebook, all of his lyrics to try to find any mention of bloods, the color red, drive-by shooting, a Tahoe, killings, 12, drugs. They searched for it. These are not confessions. These are not admissions. This is art. You will hear from the most prominent expert in hip hop. He will tell you that these words, the lyrics, they're common. These are not unique and say, "Oh, that's a Donovan Thomas killing that Tom." Jeffrey sings about cars all the time. He names all different cars. They just pulled out the top of it. Drive-by shootings. These are common themes. This is, you will learn, studio gangsters. They're in the studio. They are creating music for us to listen to. If you go to the first one, that's April 20th, 2014. It's a red just like Elmo, but I never effing give go. YFL won't fold, pick his A off a balcony, off the balcony. There's no evidence anyone got picked off the balcony. YSL, wife at ends, knows, which I showed you. I'm an F for the cash, and she's getting. He will tell you he had a rough life. He's been in custody. In a Bentley on West Lee, getting trailed by sniper, there's no evidence of that. All I ever wanted was the money. Put your hands in the air if you dare. And the MF to step over here, F and N, that's a type of gun. Put him in the wheelchair. These are lyrics that rhyme. Those are taken out of context in that song, but they're lyrics. If we're going to criminalize lyrics, you will learn. We all should watch what we say. Bruce Springsteen sings about going out west, driving with a gun on his passenger's lap. They're going to kill everything in sight. Nobody prosecutes that. But rap lyrics, you'll find out is prosecuted. Next one. March 25, 2016. Jeffrey released a song on YouTube. It's called Slime, S-H-I. Hey, this slime, S-H-I. Hey, YSL, H-H-I. Hey, killing 12, that means police, S-H-I. Hey, flick a jail, S-H-I. Hey, cook a white brick, that would be like making crack cocaine. I'm not new at this, hey. I'm so true to this, hey. I done put a whole slime on 100 licks. Slime or get slimed. I'm the VIP and I got that pistol on my hip. You praying that you live, I'm praying that I hit. Hey, this, that same slime, S-H-I. FF, the police, in a high speed. Hundreds of rounds at the top of it. The next line has taco. These are rhyming. They're not 100 rounds. in the Tahoe of Mr. Donovan Thomas. You'll have no evidence when that lyric was even created. The prosecution doesn't care. These are release dates. They have no clue that this is what they're giving to you. And is it 100 rounds in a Tahoe like bullets hit a Tahoe? Or is it someone driving a Tahoe with 100 rounds in it? It's up to the listener, I guess. But the police officers in City of Atlanta, District Attorney's Office of Fulton County, everything. It's like 24 M's on an N's head. Everything is viewed wrong. I'm prepared to take him down, got banana clips for all these ends, acting monkey. This says slime SHI, this says mob SHI, F the judge, YSL, this is mob life. That's the overhead. It rhymes. There will not be one person to come in here. There will not be one document that comes in to say the intent of that song was to brag about something that happened to Donovan Thomas or anyone else. Jeffrey's being targeted. The next one, April 12, 2018. Jeffrey released a song on YouTube. It's entitled Anybody. And Jeffrey said, I never killed anybody, but I got something to do with that body. I got the streets on my back, carry it like I'm moving a body. I told him to shoot 100 rounds, like he's trying to move the body, ready for war like Russia. I got all types of cash. I'm a general. You will hear that other artists use the same type of lyrics. Before Jeffrey, after Jeffrey. These are typical. You also learn that this is a song that Jeffrey did with Nicki Minaj. This song is a gigantic success. Now it's become a confession. It's not true. The next one, January 15, 2019. Jeffrey on YouTube, a song called Bad Boy. I shot his mommy, so now he no longer mentioned me. I had, those are shoes. When I shot the C, act like you want war, they're going to smoke you like a blunt. I shot at his mommy, now no longer mentions me. So the police are going to tell you, the prosecutor can tell you, huh? Mr. Bennett, wife Hanushi, her mother was shot in drive-by shooting. That was done by Mr. Cope. It's not Jeff. It's also January 15, 2019. That shooting happened on January 26, 2015. There's no connection. Plus, wife Hanushi, he still mentions Jeffrey. This is how bad his album is. He says in 2016 how he slept with Jeffrey's fiance. These are just lyrics. These are art. Criminalized books, movies, and other forms of music. How come other forms of music don't get criminalized? Next, September 16, 2019, Mr. Arnold, Jeffrey Williams, it's called Just How It Is. Jeffrey supposedly saying, I escaped every one of the licks because I was supposed to be rich. I don't care nothing about no cop. I'm telling you just how it is. Hit him with a Mac now, his whole body scab. I done for the crew, I done did the rob, and I done did the jacking, now I'm full-time rapping. Last end tried me, got popped at Lennox. Ask the cops, ask the detectives. They all know the business. Ask the cops, ask the detectives. All the jurisdictions. Gave a lawyer close to $2 million. He handles all the killings. We don't speak about S on wax. It's all mob business. We know to kill the biggest cats of all the kidneys. And that has to be Donovan Thomas, right? It just has to be Donovan Thomas. There's no evidence that that's true. That's what you're told. How much money Jeffrey paid to lawyers? For other people? Hardly anything. You'll see a chat that Jeffrey's asked to pay $2,500 to someone's lawyer. He doesn't even do that. He's asked to pay for lawyers all the time. He doesn't do it. He's not the head of a conspiracy. He's not in a conspiracy. They are lyrics. The next one. It's December 18, 2020. This is Mr. Kendrick, Mr. Kitchens, Jeffrey. And they released a music video, Take It to Trial. This is a very popular song. This song was based on another song called Take It to Trial. They changed the lyrics. So that was the inspiration. Take this MF trial. I rep for my life for real. For slimes, you know I kill. Trial. I done beat it twice. State. I'm undefeated like feds. Came and snatched me. I don't know. No point in asking. I was unbelievable. That would be like Cleveland, except the C was dropped for the B. Stuck like a magnet, BITASS, and I shot at your mommy, need to stand down. I up my stamina, take it to trial, get an appeal, take it to trial, yeah. You're gonna whack them, pay for the casket. It's just if we whack them, my young ends pulling up Bentleys, Aston Martins, nice Teslas strapped with the FN choppers, carbons. YSL, slimy and shady. Watch me whack that B, pop them like a cyst, Glock with the assist. And that is your confession. Stuff goes around the world. Now it's held literal, Jeffrey. It's outrageous. The next one. It's April 16, 2021. Jeffrey released a song on YouTube. Really be slime. The lyrics, my end really, they slime. We committing them crimes. Hop out and shoot. Roll one up for the gang. Want to be a slime? Go catch a body. Me and little bro, we used to steal from the store. We had to stick it and go. That's a confession to an armed robbery.
I'm really trying to figure out. Shout out to everybody who's watching. If you will, just give me a follow.
These lyrics are accurate. This is the interpretation
my YouTube channel. I'm really trying to see if they're actually going to use Young Thug's lyrics to really prosecute, because
lyrics in rap.
I've never heard of lyrics being used
in gangster rap
in anything else but rap music, as far as court cases or the judicial system go.
They have 5 gang experts, but they really have 1. Because you're not going to get experts from different jurisdictions, from different types of teachings, from different learnings, from different thoughts. Your 5 gang experts in this case from the District Attorney's Office of Fulton County all work together in the City of Atlanta Police Department. Those are your 5 gang experts. They teach each other. They talk to each other. They decide what the rules are. None of them gave a report. It's just they know it because they are control us. That's what you're going to be told. They know it more than you, more than me, more than Jeffrey. They just know. We're going to have 5 people designated as experts They all are biased. They all targeted Jeffrey. They all work together. They have an agenda with the district attorney's office, Fulton County. That's our The next one. This is April 16, 2021. Mr. Kendrick Jeffrey. It's called Slatty. Killed this man in front of his mama, F little bro, sister, and his cousin. I shoot out, kill him, not leaving a trace. I had to break the safe. Yeah, I didn't leave even a trace. Dissect your body like science class and gangster cause. You got a body, little n. Magazine clips. So you might get your issue. You think you gangster because you got a pistol. Look at my trigger. My trigger starts to issue. YSL, we going overboard. Oh yeah, the lyrics found the prosecution. They searched for this. There is no safe in this case. These are simply marked. Next one. April 16, 2021, Mr. Arnold, Mr. Kitchens, Jeffrey, did appear in the video, titled Ski. I F with slats, we come to eat rats. I came with some effing piranhas. I told him FM on me, called Nietzsche Nietzsche. It's Glock, he keep rolling, Duke rolling 60s. He locked in C. Duke is the name that Mr. Martinez Arnold used. It was like Duke. Rolling 60s Crips. That's the C. Some of these words are not really the lyrics, but you can decide for yourself. You'll hear the songs. You can decide what the lyrics are. It's a wildly popular song. It's now become criminalized. Words in America are criminalized in Georgia. Next one is count 56. So those were the overt acts dealing in count 1, the RICO conspiracy, deals with Jeffrey. There are 191 overt acts. Most of them don't deal with Jeffrey. But the prosecution has indicted it through the grand jury to say Jeffrey's in this conspiracy. So the acts of a Christian Eppinger somehow roll onto Jeffrey. Jeffrey's not in a conspiracy, you will find out. That is everything pertaining to Jeffrey and count 1. Then we have to skip. So you're going to have that count 2. Count 2 is the murder of Mr. Donald Thomas. Jeffrey's not indicted for murder. And you keep going down until you hit count 56. And you're going to go through 56, 57, 58, 59, 60, 61, 62. Those pertain to Jeffrey. So that's what these are individual counts. It's not, these are just separated out. They're all in the overt acts, but now they are separated out into crimes. So 56 is from the 12th day of May of 2018 to the 8th day of May 2022. The dates are there because the indictment was returned the next day, May 9th of 2022. That's why it ends on May 8th, 2022. And it goes back the 4 years because that's something called a statute of limitation. The Honorable Court will charge you on that. But that's why you have a date range. And it says that Jeffrey, he occupies the position of an organizer, a supervisor, a management, a leader in YSL criminal street gang, and did engage directly or indirectly. Either conspired with the following criminal street gang activity: murder, aggravated assault with deadly weapon, armed robbery, hijacking motor vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm, possession of a weapon by a convicted felon. Jeffrey's not a convicted felon. They're saying that, well, Jeffrey is in bed with these other people, and therefore their acts are attributable to Jeffrey. Jeffrey doesn't even know most of these people. That is charging Jeffrey with participation in criminal street gang activity. Criminal street gang activity, you will learn, it is not enough be in a gang. That's not illegal. It's not enough to associate with a gang. That's not illegal. It's not illegal to have a blood tattoo on you. Wear red. It's not a crime to promote a criminal street gang. What makes it a crime is if you're doing all those things and you're wearing the colors and you are promoting the gang, and then you do a crime to further that gang's activity, the agenda of the gang. That's the crime. Otherwise, we couldn't associate with someone who's part of the Ku Klux Klan, not that anyone would want to, or the Aryan Nation, or any other despicable organization. America would wipe them all out. That's what Jeffrey's charged with. That's count 56. Count 57 also charges Jeffrey with participation in criminal street gang activity. This is along with Mr. Arnold and Mr. Kendrick. And this on May 9th of 2022. May 9th, I may have misstated earlier. May 9th, 2000, I don't think I did, but May 9th, 2022 is the day of Jeffrey's arrest. When law enforcement surrounded his home, there were more than a dozen people there. And what the prosecution did now is say that this is criminal street gang activity. This furthers the gang YSL, because in Jeffrey's home, where other people had access to, there's marijuana with intent to distribute. Jeffrey doesn't have to sell any drugs to make money. Possession of codeine with intent to distribute. Possession of cocaine, it's a very small amount. Possession of firearms. And it's alleged in count 58, 59, 60, and 61 of the damage we'll get to right now. That somehow promoted the gang. That was in furtherance of the gang. Being in a house where other people have access to it for these drugs now furthered the gang. That's the allegation. That's it. Next count. It's 58. Mr. Arnold, Mr. Kendrick, and Jeffrey. They possess marijuana with intent to distribute the day of Jeffrey's arrest. Marijuana is found in Jeffrey's home. There's marijuana, and it's bagged up. It was bought at a dispenser, excuse me. It said Brooklyn, New York on it. That's found in Jeffrey's home. Now Jeffrey, there's all these other people have access to it. There's no drug test. Jeffrey's using marijuana. His hand is charged. And Kendrick again and Jeffrey, it's the same thing. It's the day of his arrest. It's May 9th, 2022, and found in the home is codeine. There's a lot of codeine in the home. Buckets full. There's all these separate glasses, bottles of codeine. Attempt to distribute. It's in the home. That's it. That's it. The next one is 60. Kendrick and Jeffrey possess cocaine. It's the same day of the arrest. It's a small amount of cocaine. I'm not pro-cocaine. This is a small amount of cocaine. Now he's charged with it. Of all the people in the house, they just picked these. Next one, 61. Mr. Arnold, Mr. Kendrick, and Jeffrey, possession of a firearm during the commission of the felony. It's the same date of his arrest when the police took over the home and searched it. And it says that Jeffrey did have on his person, or he conspired with others, with parties of crime with others, a Glock 30S firearm, a Glock 357 firearm, F&M firearm, Glock 919 firearm, Smith & Wesson M&P firearm, Glock 45 firearm, which has a converter. While involving the felony of marijuana, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine, they're saying that the gun and the drugs are in close proximity to each other. Therefore, having a gun, which is not illegal for Jeffrey, except for the machine gun, converted gun. But if it's near drugs, and guns and drugs should not be together under the law, you'll have zero evidence that Jeffrey was with a gun near any drugs. There are all these other people at the house. These other people were living at the house all the time. Jeffrey would go from place to place. Jeffrey just got back into our country. He was in Ireland. He was watching Sergio Kitchen perform. He just got back the weekend before. The next count is count 62. Mr. Arnold, Mr. Kendrick, and Jeffrey were in possession of a machine gun, Glock 45 firearm with a converter switch, extended magazine. During the commission or attempted commission of participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of cocaine with intent to distribute, possession of cocaine, as alleged in count 57, 58, 59, and 60. You will hear zero evidence that Jeffrey ever touched a gun with a converter. You will hear zero evidence. This is a knowledge. You have to know. We don't trick people. You have to know that the gun is transferred into an illegal machine gun. You'll hear zero evidence that anything to do with that gun. The purchase of it, the possession of it, even knew it was in the house. Knew that it was a machine gun. That's the count. Ladies and gentlemen, that was the indictment against Jeffrey Luna. That was everything. Jeffrey has been targeted. Jeffrey does not trust the criminal justice system. Spent 10 months to choose you to decide his fate. Jeffrey trusts you. There's a wiretap in this case. There's actually two. Antonio Summons phone, a wiretap. Wiretap just means that it's called wiretap because we used to have phones with wires, and the law enforcement would get into the phone system, the AT&T system, and be able to connect to the wire for that phone. And they can listen to all incoming and outgoing calls. Today, we don't, our phones are cellular, but it's the same exact thought. And law enforcement, with the court's permission, or without a court's permission, that's illegal, can get into a cell phone on the frequency so they can capture your searches, your text messages, your phone calls, everything you do with that phone, your GPS. And Mr. Garlington's phone was wiretapped. Mrs. Someone's phone was wiretapped. And you will learn that these people who are so embedded with Jeffrey in crime, Jeffrey's the king slime, the leader of this organization. You know how many conversations in any way they have with Jeffrey? Zero. He is not on a wiretap. Zero. But others speak about Jeffrey. Hey, we did this for King Slime. He should pay for our lawyers. Jeffrey doesn't pay for anybody's lawyers. Hey, how much will King Slime, the biggest, pay us to kill YFM Lucci, Mr. Bennett, who's in the Fulton County Jail and we have access to him? How much will he pay? Jeffrey pays nothing. He doesn't encourage it. He's not even on there. But everyone talks about it. Oh, yeah, he's going to pay big. That's a big one. He really wants it done. Those people don't even know Jeffrey. Jeffrey treats whoever he is with the same. Whether he's with some giant president of a company or he's with somebody from Cleveland Avenue who's been in and out of prison, a gang member. He knows where he came from. He came from nothing. Now he stands before you. We trust you. Jeffrey's not guilty.
All right, ladies and gentlemen, how about some lunch? Yes. Good? Okay, all right. What we're going to do at this point in time, ladies and gentlemen, it's hours 1:45. Let's come back at 2:45 and we'll see where the day leads us at that point in time. Remember the admonitions that I gave you earlier. They apply to you, an inquiry of me. Remember, I told you if you leave your headquarters, leave your notepads in there, and remember all the other admonitions I told you about contact and otherwise discussing with each other. You're not permitted to do any of that, any other admonitions I gave you. So we'll see you back at 1:45, and we'll, like I said, we'll continue. I'm sorry. Okay, all right. I'll give you a few minutes. All right. So yes, come back at 2:45. All right. Unless there's anything else, ladies and gentlemen, let's enjoy your lunch. We'll see you at 2:45. All right. All rise. All right, ladies and gentlemen, please be seated. All right, unless there's any other inquiry of me, I'll see you all back at 2:45, okay? All right, we're in recess.
Your Honor, before the court leaves, I just wanted to make certain that I have an opportunity to address the matter that we addressed at the bench during the state's objection. I can wait until after lunch or whatever time the court designates.
It was already taken up and recorded at the bench, so.
That part, not the objection, Your Honor. It was the motion in limine that the state wanted to make that goes along with that. I can wait until whatever time the court designates.
Let's just do it now. What is it?
Okay. Your Honor, I wanted to move the court in limine to preclude any attempt to admit self-serving hearsay, Mr. Williams himself, anything that Mr. Steele has represented to the jury that Mr. Williams thought or felt. Mr. Steele announced at the bench that he expected that information would be coming in through evidence. And so if there is no such evidence at the proper time, the state may move for a mistrial. I don't
think
what'll be done at that time.
Here's the thing. If he doesn't prove what he says and he has already promised that there are ways to deal with that. So I'll leave that within your lawful means. Mr. Steele, anything else, sir, in terms of that particular conversation? No. All right. All right. So with that, unless there's anything else, we'll go ahead and recess until 2:45. All right. Recess.
people to work. Not meant for brainwashing. It's whatever the consumer chooses. It's art. Looking at a painting, watching a movie, reading poetry. It's what you believe it be. That's what we do, as opposed to Russia. They stop all communications. They censor. The next overt act, March 20, 2015. Jeffrey is with Shannon Stillwell, Diamante Kendrick, Mr. Garlington, Mr. Arnold. And they are using their hands to make signs. That's further, that drives this conspiracy. That's it. Jeffrey didn't even release that photograph. Who released it? Mr. Garland. Next. It's almost New Year's 2017. Antonio Sumlin also comes from the impossible life that Jeffrey was born into. He's with Jeffrey. There's a social media captioned "Original Slime SHI." Jeffrey saying "Murder Gang BIT." And holding up his fingers. It's YSL. Until we're dead and pale. That's the overt act. That's driving this conspiracy. Next is August 8th of 2019. That is Mr. Bennett. He's a very, very, very prominent musical performer, rap, gangster rap. It's August 8th, 2019. And this is Jeffrey's post. Jeffrey did post this. And he wrote, YFN, meaning Mr. Bennett, if I ain't like what you do for your mother and kids, and capitalize, I would have been kill you. That's supposed to be this rival, this leader of the YSL, the King Slime, against IFN. Here we go. What they don't tell you, but what you will learn, is the day before, Jeffrey released an album called So Much Fun. YFN.
All righty, we're going to take a break here. We're going to be coming back on the other end. We're going to be listening to a little bit more of this opening statement, but also I'm really excited that we're going to be able to take, or I'll be able to take viewer questions to give to our audience, or rather our guests to answer. So I'm really, really looking forward to that. So we take a quick break. We'll be back on the other end. back to the Law and Crime Network. My name is Bob Bianchi. We're here to catch you up on opening statements in the Young Thug Rico trial. Court is currently on their lunch break. So far, while we wait for them to return, we can continue to catch you up with the defense attorney, Brian Steele, very lengthy opening argument. Like I said, on the other end, we're going to YouTube with some new guests on here to be able to answer some of those questions. Really excited about that. Let's get back to the ending of these opening statements.
Social media. That is awful. And what you also will learn is that in 2016, years before, YFM Lucy, he's not as high as, he does not have as much fan base or interest. He doesn't make the money that Jeffrey does. So YFM Lucy does what all these rappers do. They attach to somebody bigger to promote themselves. He did that too. He did it with Lil Wayne. He did it with others. In 2016, Mr. Bennett or YFM released on social media that he has been having sex with Jeffrey's fiance. So King Slime, all these years, this man saying that he sleeps with Jeffrey's fiance goes unharmed. Nothing done. This is the post that Jeffrey says. And it's a real threat. If I didn't like what you do, for your mother and your kids, I would have been killed. Doesn't sound like too much of a threat. That's the over there. The next one is March 12th of 2020. Mr. Huey and Mr. Williams. Now, this is not social media. These are actually conversations that the prosecution subpoenaed from Google or from Instagram or from Twitter or from Facebook. You get all of Jeffrey's statements. This is very invasive. And what happened right before the date, this is right before COVID hit in 2020 in America. Sergio Kitchens, as a dear friend, co-worker.
Okay, so that's pretty much the ending of the opening argument that was just a little bit over 2 hours. Very lengthy, very detailed, interesting argument. Was going to be a very long and protracted trial. So I think the prosecutor's on the run so far, but they got a lot more to go. We're going to take a break. We'll be right back. Welcome back, and thank you for joining us here at the Lime Network as we kick off our third and final hour of our 3-hour coverage. We're following opening statements today in the Young Thug RICO trial. Rapper Young Thug and 5 co-defendants on charges of racketeering and participating in a criminal street gang known as YSL. That's short for Young Slime Life. Prosecutors allege that Thug, whose real name is Jeffrey Will, founded the gang in 2012 and rose to prominence through references to gang activity in his song lyrics. The defense alleges, however, that YSL is nothing more than a record label. Court is currently on their lunch break, so while we wait for them to return, let's continue catching you up on the defense attorney Brian Steele opening argument. And yes, for those that have been watching for the previous 2 hours, it is true. Get to viewer questions that are coming through to us on YouTube. I was just in the control room looking at them. They're awesome. Can't wait for it. But in the meantime, let's take a look at the the opening arguments.
He is a producer, an engineer, musical engineer. So Sergio Kitchen performs. This other person turns the music, the beats, makes it right, changes lyrics, does whatever they do. This producer or engineer's name is Chandler Durham. He goes by Turbo. And Turbo's car was stolen. And in that car are beats, lyrics that cannot be reproduced. Copied, they're on in a hard drive in this car. The car's stolen. And it is alleged that Mr. Huey's friends or people that Mr. Huey knew took that car. Not that Mr. Huey did it, but that he knew who did do it, who has that property. And Jeffrey writes to him, if he don't take it back, he's going to die. Give back the property. You will learn that no one died. You will learn he was never given back. That is the real leader of this feared criminal street gang. He's ignored. That's it. That's March 12, 2020. The next one is February 4th, 2021. Now this again is the Trantavia Stevens. He grew up with Jeffrey. They exchanged clothing, dirty clothing. They went hungry together. And Woonie Lee is also a up-and-coming musical artist that Jeffrey wanted to sign, but Woonie Lee went to another record label. He supports him to encourage his career. And this is February 4th of 2021. And what the indictment did by the prosecution through the grand jury, put this together, and this is bad. I understand when you read it.
Objection to your argument.
Thank you. This reads, YSL ruled the world, kid. 24 and an N head. Y'all just start bringing me the money. Man, y'all and stop playing with me. So when you read that, it sounds like there's a contract on someone's head. Kill him, start bringing me the money. Stop playing with me. That's threatening. What you will learn is what the prosecutor did was they took these checks from various days. This is over a 3-day period. This is February 4th, 2021, all the way up to February 2nd. And they cut out all of the context. And what you will learn is that on February 4th of 2021, Jeffrey wrote, YSL rule the world, kid, 24M on an N's head. What happened on February 4th, 2021 that was released on social media and went around the world is one of Jeffrey's artists that he signed, he developed, he encouraged, and who made it. This person had a supposed, maybe it's real, $24 million pink diamond and had it surgically implanted into his forehead. There is a photograph next to YSL Rule the World Kid, 24M on an N's head. There's a photograph. If you click on it, it is with the surgically implanted pink diamond in his forehead. The police bury this. The prosecution buries this. I will show you. Now, the evidence will show, they may say, oh, it's on. We may say, there's no mistakes here. This is a big deal. This is a bill of indictment in Fulton
Objection, Your Honor. Argument.
That is misrepresenting. You will learn. You will see it. It has nothing to do with put a contract on someone's life. That's the evidence that's coming at you. You'll start, bring me the money. Y'all, and stop playing with me.
Okay, and here we go. It's the first time I'm actually doing this in a really long time. I've always loved doing this from years ago at the Law Crime Network. And as are watching and you're putting your questions in, they're always so perceptive. And I love being able to be on a show where we have real talent that can answer these questions because they have the background and experience to do it here on the Law Crime Network. So we have Sonny Slaughter with us. I say Jersey girl. I don't want anybody to get upset. That's a phrase we use in Jersey. There's no disrespect meant in that. First herself and such. Sonny is a good friend. She's a law enforcement instructor. And if you watch her social media, obviously makes a mean dish. The other day I was watching it. It looked delicious. As a trial attorney and to my heart, a former prosecutor. So that's all good here. Okay, guys, listen, our audience here at the Law Crime Network, they watch these shows. They're really perceptive. I'd say any lawyer that's trying a case should be looking at the questions that our audience are asking, because this is what's going on in the minds of the jurors. And a lot of times as lawyers, we forget that. So let's start with Fillmore Tim from YouTube. Okay, I'm going to do this to you, Sonny. What qualifies as a gang expert if they weren't around a gang? So that's really so qualifies to want to be a gang expert. I guess if you weren't in a gang, you weren't around a gang. How can that happen in a courtroom?
So usually a law enforcement expert that is also a gang expert or someone that has had some type of background, may have worked undercover, also has studied gang, the terminology, the behaviors, the acting about it, but they have some extensive knowledge of gang behaviors and gang actions and activities. So they are usually studied. Now, as a former prosecutor, both of you, not anybody can just be a gang expert because the courts are going to qualify them. The prosecutor is going to tear them apart, or the defense is going to have to have some level of extensive knowledge about gangs, gang activity.
Yeah, and I always like to fill this in when you look at the evidence rules, right? Because that's like the Bible as to what gets into an expert doesn't have to necessarily be a part of anything. They just have to have a specialized knowledge that's recognized by the court that gives them more knowledge than the average they call it, or average standing of an individual. And it's up to the jury to make a decision as to whether or not that training and experience they have is worthy of belief or not worthy of belief. So you will see, it's a great question, cross-examine an expert to say, well, you were never in a gang, or you didn't do this, or you really don't have practical knowledge, you have book knowledge. So they get admitted as an expert, but the level of credibility or testimony is always left to the jury to make that determination. Bridget, let's go on to Ruth Ann Halshak from YouTube. The question here is, of an organization as per the state, when using RICO, isn't it that if one in the organization commits a crime, then everyone in the organization is charged. And I asked my producer, and I'm gonna see if I scroll down if I got an answer to it. TIA was after to show you how old I'm getting. I'm like, what does TIA mean? Thanks in advance, of course. You're welcome, Ruth Ann. It's MP. My pleasure. Bridget.
That was good. That was good. So to answer her question, the question was, if one person is found to be a part of RICO, is everyone also a part of RICO? I think that's what the question was. And the answer to that is just no. And so when we talk about if one individual is saying, okay, well, I've been involved in the organized crime, fraudulent or illegal activity going on in order to produce a profit, who's to say that Mr. Jeffrey or YSL Young Thug was a part of that as well? And so that's the reason why the defense counsel is going through every instance. He's taking his time and he's going through every instance with a fine-tooth comb to say that YSL Young Thug was not involved in these specific instances, to show that he was not involved in this racketeering charge at all. So there could have been other members who were involved, but that does not mean that Young Thug was, and it's the prosecution's job through every element that it was in fact Mr. Jeffrey YSL Young Thug that was involved in this charge.
Well, let me follow up with you on that answer, because the other one that Akalia from Lancaster from YouTube asked, if a jury finds one guilty, do they have to find them all guilty, considering it is a RICO trial?
Again, it goes back to that finding of, has the prosecution found every person that's been involved guilty of this particular charge? Not just the prosecution, the jurors, excuse me. And so when the prosecution, have they fulfilled their burden? Once we get to just, okay, people have been arrested, okay, that's a lower burden. That's, have they been arrested? Has they can arrest them if there's enough evidence to prove the elements by probable cause. But the prosecution has the burden to go even further and beyond a reasonable doubt. And that's where we are now. And so if they can do that and the jurors believe that every element is proven beyond a reasonable doubt for this defendant, then the state can move forward and say, okay, well, now we are going to move forward to the sentencing, and that person will be charged with this or convicted of this particular offense.
Sonny, let's go to Tall Grass from YouTube. And the question is, do you think the state stopping the defense's opening statement helped or hurt them?
Well, I think it was necessary to get in what they wanted to get in, the information that they wanted to get in. Now, whether it's hurt them, will vary whether they perceive that particular stoppage as hurt, even though they were not present. So I can't say and won't say whether it hurt or harmed them, the opening statement. And it might be confusing to the jury, but I think on the defense's side, it felt necessary.
Yeah, and just to follow, I think that we're talking about the where they're asking for a mistrial because the slides were not provided. Right. And again, I think that even if a jury isn't listening to all the arguments, they have a very good sense of what's going on in that courtroom. And my sensibility to answer, at least from my standpoint, was as a prosecutor, I don't want the jury knowing or having the judge give. A lot of times communication is occurring that's not verbal, that I've done something wrong. So I think if the defense is right, you don't want to object a lot in the openings, but that could be something defense in the backside, because they look at the judge very carefully in terms of how the judge rules on things. Now, let me just follow up with you on that, Sonny. Baritone 90 from YouTube also asks, if a prosecutor objects, do they have to wait on the judge to return for a ruling?
Yes.
So pretty much.
They need to, yes. They need to wait for the judge to determine whether or not there was a reason for them to object, or, they just can't keep going and going. The judge now the judge may make a decision right then, or the judge put it off later after hearing additional evidence. But yes.
Okay, and Bridget, let me ask you: do you think that the judge? This is really a great question. It's off biased in the case.
I don't think he comes off as biased. I mean, one, the trial's just getting started. We have quite some time in this. They project at least 6 months in this particular trial. He does show that he is frustrated with the prosecution in the actions that they have taken so far when they presented evidence in voir dire that they should not have. But that was right. He should have showed that frustration because, like he stated, he gave over 10 days to provide all evidence, all discovery to the defense counsel. And so if you are going to be putting anything in front of a jury, anything that is evidence or just something that shows that they're going to be playing throughout the trial, then the state has the responsibility, the ethical responsibility to provide all of that. Then that is a problem. And Mr. Steele, defense counsel, rightfully so, I would have done the exact same thing, filed a motion for a mistrial. And so even though that was denied, he did his job by saying, okay, well, we understand that that was something that was presented to this jury. It should not have been shown, and we're going to move for a mistrial.
Right. Okay, Tall Glass had asked that question as well, a little 2 cents about this. There is a dance that goes on in a courtroom between a judge and the attorneys that are trying the case. Now, sometimes judges can be excessive, no question about it. But if it think that their ruling has been flagrantly violated, or they believe that they need to put you in control as a lawyer, they will start to allow that to bleed over into the courtroom and in front of the jury, is kind of to say, don't make me have to do that again. So it's kind of a push and a pull. Again, some go too far in doing that, but sometimes they also want to show that frustration. And that has a leveling effect, if there's no doubt about it, because as a lawyer, you don't want to look bad in the eyes of the judge, because the jurors really respect the judge more than any of the other people involved in the court process. Awesome questions. Keep them coming. We have to take a break. Really love doing this. Can't wait to continue on the other end. Please stay with us. All right, away we go. As we wait for court to return from their lunch recess, we have questions and answer session here where we're taking your questions and they're coming across on our YouTube channel. So let me go with try to piece a couple of these together. So I think it's Bryn West from YouTube. Ladies, asked the following question. What do you think of attorney Brian Steele? That's the defense. Paul Grass, again from YouTube, asked the question, what is your opinion as to which was better, the state opening or Steele? So, Bridget, let me start with you. What do you think generally is Steele's opening? I think most lawyers would say it was a lengthy one, not that there's a time limit on it, and it was very detailed where defense attorneys typically don't do that. What are your thoughts?
Well, it was extremely lengthy, but this is going to be a very lengthy trial. And so he is trying to get ahead of the state's case in chief. This is the time that Mr. Steele has evidence before the state brings their case in chief. In any trial, the state gets to go first, right? So they bring their case in chief, and then the defense has their opportunity. But prior to that, this is the opportunity for him to lay out specific instances and say, well, this is what the evidence will show. This is what we anticipate will be happening. And so he's going through those things very carefully and explaining to the jury, this is what we anticipate will be coming up in this trial. And he's also trying to explain it to the happen. This is why this happened. This is what is being considered an overt act. This is what the state is saying, is really tying to this racketeering charge. And so he's trying to explain to the jurors, well, these instances really shouldn't be tying him to these charges before the state has the opportunity to say, these are the instances that tie him to this charge.
Yeah, and so I just want to get into that and just follow up with you on that. A lot of there is truth. You have to tactically do things differently in each trial, while defense typically doesn't have to. It has no burden. It doesn't have to even give a statement. And then typically they don't give a very detailed one. I like the idea he came out forcefully and was attacking the prosecution's case, because we all know the opening is the most important thing in a case, to formulate their mind right from the beginning, and he needed to counteract that. So let me follow up with the question, do you think that when you balance, what did he, in your mind, do a better job than the prosecution did in the job? And I'm trying to look for who one of the folks here asked this question, and let's go to Maisha of YouTube, because she asked this question: do you think these extended opening statements hurt or help the prosecution? We haven't been able to pull the pieces together yet, and it feels already, Bridget, I'm going back to you, because as a trial lawyer, if I'm a prosecutor and one of my people is looking at this and they're telling me when I go back into my office that my Aisha is saying that she feels the pieces pulled together and the opening statements are really long, I got the burden of proof. I'm nervous as a prosecutor when I read that question.
Well, that's true. First of all, have a very long attention span. So we start there. We have to make sure that we start out the gate getting the jurors' attention. And so, but the issue is that in this type of case, in this racketeering case, there are so many moving factors. The state alone is projected to bring over 400 witnesses. And so when you talk about that, there's no way that their opening statements long. That they can't cover everything that they need to cover in 10 minutes. They have to at least go into some of those specific details to show this is where we're going to be going throughout this trial. It's kind of a roadmap. And so they are trying to set that precedent to show the jury, this is where we're going. Right. But the issue is that it's difficult for individuals to go out throughout that trial. They'll be able to reference back. Well, remember an opening statement, I said this was going to happen. Remember an opening statement, we talked about this and that the evidence wasn't going to show that. That's what they're doing. They're just planting seeds. And so that way, when we get to the trial, they'll be able to say, well, I talked about that in opening statements, and each of you promised to follow the law. Well, so that's what they're doing.
Tell you what, Miesha, if I were to read, haven't been able to pull the pieces together yet, and it feels overwhelming as a prosecutor who's got the burden of proof, of proving a case beyond a reasonable doubt, I'm nervous I didn't put it together in a way that the jury understands. I'm just saying. To you, Sonny, on this one, because it was from Tallgrass, again, was asking which, in your opinion, was better, the state or the opening, and I want to caveat this. Because what does better mean? Well, there, and I'm kind of moving around with people's questions, is she's a little overwhelmed and she doesn't know if they're putting it together. I don't like that from a factual standpoint for the state, but I'm going to give you another one. I'm not sure if you saw this, Sonny, an issue where the prosecutor in the opening statement, in my mind, got dangerously close. In fact, I think, at least from New Jersey standards, it would be an appellate issue of monumental problems in shifting when the prosecutor's saying you're not going to hear anyone from my case, say that they were in a gang or something to this effect. But where's the information coming from that it's not true? In other words, saying, and there was an objection at that point in time, that there was burden shifting that went on there. You never comment on a defendant's right to remain silent or anything that could be inferred defendant's right to remain silent. So to answer Tallgrass's question, at least from where I come from, is I got Miesha over here who's a little bit overwhelmed in not knowing what the facts are, and I got a prosecutor who, in my opinion, created a major legal issue right in the beginning of the case. That was very amateurish to me, which I would imagine this is a sophisticated and experienced prosecutor. Thoughts?
I agree. And, also being from New Jersey and starting my entire life out with New Jersey criminal law and how things unfold, a prosecutor ever make that type of mistake, because that also sits in the minds of a juror. Oh, so the defendants might not testify, they might not be able to say this. All of those factors play into, as you said, a potential appellate court decision and the defense counsel having to object moments. And this is a RICO case. This is not a small case. I also heard the defense attorney really lay out some nuggets about law enforcement, due process, and may come into question. So I think it's really important that burden shifting never happen, and that the jury is also paying attention. Now, Miesha might not have the nuggets all put together, and the roadmap might not look like it's going straight, but that might be problematic as Miesha and others, I should listen to the case and say, well, wait a minute, the prosecution said this in defense. Yeah. It caused an objection, and will this somehow be problematic later?
And look, at least where we come from, prosecutors drilled. Don't say anything that could even possibly, in 1 million connective points, be perceived as burden shifting or commenting on a silent, because even if the prosecutor didn't mean to do that, at least a conservative appellate court, or a liberal, I guess, if you want to say, like in New Jersey, love to reverse convictions because they believe prosecutors went over that sacrosanct line. It just is not necessary to throw into a trial. Okay, we got one more before we have to take Bridget. This is a great question from Ashley Perry. When we have a witness on the stand, will each lawyer cross-examine for their defendant, their client, or are there certain witnesses that only pertain to one person?
That's a very good question, Ashley. So whenever there is a witness that comes on the stand, there may be where the defense counsel for Young Thug, he decides that he wants to cross-examine, then the other counsel, if they choose to, they can do so. And so it is up to them if they have questions that they want to cross-examine this particular witness about. This provided the witness list to all defense counsel. And so everyone knows who's going to be coming up or can potentially be coming up as a witness. And so they should be prepared for cross-examinations that may be coming up in this trial.
Yeah, I could tell you as a trial trainer, Ashley, that every lawyer has a right to question every single witness that comes on that witness stand. That is a great, really good nuanced question. Is just because you can, ladies, you know this, doesn't mean you should. And on that note, we're going to take a break. We'll be back. Please stay with us. Okay, while we wait for the court to return the Young Thug racketeering case, we are on a lunch rest right now. We have some questions and answers, taking your questions, the viewers from YouTube. They've been great, and my awesome guests have been doing a great job in answering them. Sonny, let me go to you on, and this is such an interesting question in terms of the court dynamics and what really goes on inside that courtroom, because we are human beings, and when we see it on TV, it looks a certain way. It's kind of a dress rehearsal, if you will. So Munch, I think it's Monch from YouTube. Would the judge call recess if he notices the jury being antsy or falling asleep?
Yeah, sometimes the judge might say, we probably need to take a little break. But usually they're focused more on what is happening, the other dynamics. And the clerk might motion judge that people are falling asleep. But that can happen.
Yeah, and my experience, Bridget, I'm sure you've seen this as well as Sonny, is the judges of, like I said before, very pays up because the jury looks at the judge as the person that doesn't have an interest in the game, that they're the arbiter between the defense and the prosecution. And the judge is always giving them something. The judge is giving them their lunch, and the judges are always so kind, typically speaking, most judges, to the jurors. So the jurors really look up to the judge. That's why you don't want to get a judge's ire in front of that jury unless you really have. Judges typically are very, very responsive to jurors who may be tired or antsy, or they may not feel well, or things of that nature. So Inquiring Mind from YouTube asks kind of an additional question. Inquiring Mind asks, this case is too much for this judge. That's the opinion of this individual person. You can comment on that if you'd like. And how are judges selected for big cases?
That's interesting. So let's go to if this is too much for this judge. I'm not really sure exactly what we mean there, but when we say too much for him, I think he's handling it actually quite well. He has made sure that he has reined in or any issues that the prosecution may have brought up, or even the defense counsel. He's making sure that everything stays on track. And he is very cognizant of what's going on. He rules on the objections immediately. He's making attention to everything that's going on in this particular case and to the jurors. So I think he's doing a great job. And so when we talk about if it's too much, I don't think it's too much. Now, that may be a state-by-state thing, but here in Texas, where I am, the judges are selected at random. Really, whenever a case is presented to the district attorney's office and then it moves from the district attorney's office to an actual court, it is done at a selection at random. So there's not a way that it's just, this judge is going to have that case. No, it's a process, and it falls into this particular judge's court.
Yeah. Okay. Interesting. I want to go to a question. Jesselyn here from Twitter asked Sonny, of the plea deals, when the state is not even allowed to mention the deals to the jury, and most defendants are allowed to plead the fifth. I thought the main reason behind offering plea deals was to get, quote, the head of YSL, Young Thug.
So when they offer them a plea deal, they're usually looking for something in return factors there. There's some additional information that they want, but plea deals are not unusual. They can be expected. This is a RICO case. And you usually want something, if you don't get what you need, then the plea deals are taken off of the table. The individual has the opportunity sometimes to go back and say, yes, usually before the trial starts, afterwards, folks don't want to do that. But then in some cases, if the prosecution feels like they can, and the defense attorney wants to go and make that opportunity for them, but you don't necessarily about the plea deals, because if they have not been accepted, then it's almost like, in my opinion, they were not offered. So there's no need to have that discussion around something.
Yeah, now I'm not sure exactly if I understand the nature of the question, but I will say this just so that we can round that out. Most courts have evidence rules that do not allow the plea agreements to be admitted into evidence. Again, it's one of those evidence rules because they know that would chill agreements where they could resolve cases. However, when somebody does take a plea deal, testify favorably for the government, and the government uses that individual as a witness, it's almost certain that the defense attorney is going to be able to examine that witness. Well, you're only testifying favorably for the prosecution because of what they call expectation of benefit. You expect to get a benefit for your plea deal. So a plea deal that's not accepted or as part of a settlement that's not accepted is rarely, if ever, admissible in a courtroom in general, unless there's a specific reason why it would be. But a plea deal that is accepted, and then the person gets on the witness stand for the state, sure the defense is going to bring it. In fact, you can be assured the prosecutor, a good prosecutor, is going to bring that out in direct examination because they know it's coming with the defense. I'm curious in terms of your thoughts as to whether or not, I don't know if there were time limits, and this is a question that Nessie 1015 asked to present the opening arguments. But in my experience, typically speaking, most judges don't put time limits on. What should be the time limits? How do you, as a lawyer, make a decision as to how much becomes too much?
You're correct in that most judges do not put time limits on them, especially on a case of this magnitude. On smaller or something like that, assault that may be a misdemeanor, there will be judges that will put time limits on your voir dire or even your opening statements as well. And so that has happened. It's happened to me quite a few times. But in a case of this magnitude, the court generally doesn't do it because, again, there are so many witnesses, that there's so much evidence. There's so many specific instances that these attorneys are going to be going over in this trial. And so they're not going over each specific instance, specific detail. They're just kind of grazing over it. And so the judge is giving them some free will and free reign here to go over it. I think every case is a case-by-case vetting how long an opening statement should be. We don't want it to be too long to where we lose the jurors and they're not paying attention to us, but it should be enough to give them a roadmap of where we're going, what to expect, and what we're going to be seeing as we go throughout this trial.
Yeah, that's really great. So listen, I think we're going to take a break, but when we come back, if we do have time, question that Tallgrass is asking, and I want everybody to think about it before we take this break, because it brings in a lot about nuance and evidence in the case, and that's this issue about whether or not we think the lead used against these artists is part of the evidence in the case. Hopefully we'll be able to get to that question. We're going to take a quick break. We'll be back on the other end. Please stay with us. All right, welcome back. So while we're waiting for the lunch break, we got the questions coming in from the viewers on YouTube. And Tall Glass from YouTube, I teased your question. It created quite a bit of 3 minutes of spirited dialogue with my guests here. And so it's a great question. And the question is, in case you're just joining us, you think the lyrics should be used against the artist? Bridget, we'll start with you.
You know, so I'm a defense attorney and attorney through and through. And when I say that I don't think that the lyrics should be a part of the record, I truly mean that. I think that it's a bit overreaching. Unless the state has exact evidence from a particular offense, then it shouldn't be admissible. During our break, we talked about the difference between admissibility and credibility. And sometimes the judges, they will allow the lyrics in because they were saying that it is admissible because it's relevant, right? And it's up to the jurors to decide if it is in fact credible or related to what's going on in this particular situation. But I feel like it gives the state an opportunity to overreach, and they can bring in all the lyrics or conversations from different aspects that they choose to. Like, where do we draw the line at? Where well, this is enough. That's enough. We shouldn't be bringing in additional evidence from a lyric or a song that may be completely unrelated. We have no idea what that means.
All right, well, Bridget brought the fire in terms of denying the prosecution. I'm going to play the prosecutor role at some point in time, ladies, or maybe the judicial role, as I give Sonny an opportunity to answer the question that's being asked right now, Glass, which is, do you think the lyrics should be used against the artists?
I think when the lyrics are used, because I've had this happen and I was working on the prosecution side, but it can be problematic in the sense Harry may perceive the lyrics to be one thing. And when you think about rap lyrics, and you have to think about culture, you have to think about lifestyle, you have to think about reason, and these lyrics were created. And unless the jury can put themselves in that particular mindset to think about all of the nuances that are related to rap lyrics that they may or may not understand, I think it can play it can play for the prosecution, against the defense, and be problematic for the jury.
Okay, I as the judge will sit here and say, I think that's it. Tall Glass is a great question. It really evidence rules, and the evidence rules is all evidence that's relevant is admissible. And if it doesn't make a difference whether or not you think it's right or it's wrong, unless under a Rule 403 finds that it can lead to undue consumption of time or confusion of issues to the jury. What the judges typically say in cases like this is, I'm going to allow it to be admitted, but whether the jury believes it or not, you can move to them down the road. At least that's how I see most judges ruling on a situation like that. But these ladies certainly have presented both sides of an argument because it can be abused. But you know what? That's a defense attorney's job to do, to say that it, in fact, was abused. So that is a great question that brings us to evidence rules and the practicality of what happens in a courtroom. The evidence gets in, one side gets something, one side doesn't get something. So it's so in your evidence rules. Ladies, we got couple more great questions here. So let's go to Christina from YouTube. She asked if the ones who took plea don't testify, will their deals be revoked? Now, let's, for purposes of assuming this question is that the plea deal that they took required them to testify truthfully in court. So I'm going to, if ones that took plea deals to testify truthfully in court don't testify, Bridget, what happens to their plea deals?
Whenever someone takes a plea agreement, they are telling the court, because they have to take the plea in front of a judge, that they are going to abide by the terms of this particular plea agreement, right? And so they are saying to that judge, I'm going to abide by the terms of this agreement. And so if they choose not to do so, then yes, then the state can change whatever that agreement is down the line through us if they are going to do that. And so it is they should be abiding by the terms that they want to continue to have the benefit of for the state to abide by the terms of what they said they would be getting.
Yeah, Sonny, I think you're going to probably pretty much agree with that. And the only reason I'm going to ask you is that I got 2 speed round questions for you ladies before we end the show. But why on that answer, or are you going to stick with it?
I stick with I agree with Bridget's everything.
All right.
On point.
All right, ladies, got 2 speed round questions, 60 seconds to answer them. GME to the moon. GME to the moon. Okay, ask. How much money will this trial cost? Have it, Sonny.
At least $20 million.
All right. How about you, Bridget?
It's a 6 is quite a bit of money.
Okay.
It's a lot.
Yeah, it certainly will. Okay, we got 1 minute left, ladies. So, tall glass again from you to.
Well, based on what they have presented so far, I believe that RICO fits what law enforcement and the prosecution has said.
How about 15 seconds?
I do think it was charged correctly. It's now up to the defense counsel to show that it is not enough for conviction.
Yeah. It's very, very difficult when you're making these charging decisions. You're bringing in all sorts of conduct. But to the question that had been asked before, you can make it very confusing for a jury, and prosecutors don't want jurors to be confused. Ladies, thank you for those excellent questions. I know it's hard to answer things that are on the spot like that. That's it for me, but don't go anywhere. Stay tuned for our regularly scheduled program. I'll see you next Tuesday. Have a great rest of the week.
Radio check. I can't hear you.
You said repeat all again after?
So what, Judge?
You said repeat all again after?
Radio check. You good? I can't hear you. If you can hear me, hold on just a second. All right, ladies and gentlemen, please be seated.
All right, members of the jury, you good? Yes. All right, that's like what I like to hear. We're going to go ahead and continue with a presentation of opening statements. At this point in time, who is the next person to give openings? Or?
Williams.
All right, Ms. D. Williams, you are welcome to begin whenever you like, madam.
Thank you, Your Honor. Hope everybody had a good lunch. So I'm attorney Angela D. Williams, and I have the privilege of representing Ysl Trial over there in the back. Poor, young, convenient. That's all it takes to become the target of the state. I'm gonna break that down for you. Poor. Ysl was born on a couch. Let that sink in. He was born on a couch. From day one that he was brought into this world, he has been fighting to survive. The hospital was only 5 minutes away. I don't want to throw a school under the bus or anything, but the elementary school and middle school that he went to, 98% of the children there were on free or reduced lunch. What that means is they live at the national or under the national poverty level. At one point, the Atlanta public school system was under scrutiny. They accused educators of cheating the students. The DA kept going around saying, we got to think of the children. We have to think of the children. These children are victims. The only time the state cares about poor people is when they can exploit them. For the RICO trial for APS, they got a conviction of educators. And they didn't get any of those students any.
Our cases. Us sustain the objection.
Okay.
Go ahead.
And in this case, they're trying to get a teenager for RICO. Young. Growing up on Cleveland Avenue is a very dangerous, destitute place. Ysl learned early that he needed to adapt. And he did what most teenagers and preteens do. They mimic. I remember when I was younger, growing up on social media, I used to hold up the C symbol all the time because I used to love this group called Cold Rain. It was my favorite group. I used to hashtag everything, cold rain, cold rain, cold rain. After every post, it would be cold rain. It would be rain emojis. Fortunately for me, I didn't grow up poor, so the state didn't care what I was doing. Unlike Ysl, if I had grown up on Cleveland Avenue with all these rain emojis and C, I would have been accused of being a crook. I would have been a gang member.
I sustain.
They would have said that I was.
Oh, that. You can go ahead and continue, madam.
Thank you. They would have said my rainy emoji said some murder that happened. Convenient. Ysl is here because when he was 15 years old, the state told this incredible tale of murder, and when you're young and you don't have the means, it's hard to refute those claims. From the age of 15, Ysl has been in 3 different prison systems. He's been to juvenile detention because they were holding him for the murder. He went to Fulton County waiting for the murder, and once he finally turned 18, they sent him to the Department of Correction. And I don't know about you, but a lot of people in here haven't been to prison. But if you've ever gone to prison, you would know it's overcrowded, it's underfunded, it's violent, and you have predators everywhere. And unlike maybe college or a new job, you don't get an orientation when you first go to prison to figure out how you need to do anything. Ysl had to do what he's had to do since day one, survive in prison. And if you look at Ysl, you can see he's maybe 100 pounds soaking wet. So he posts things. He posts things on Instagram.
And I wouldn't even call him Instagram post. I would call it a survival post. He has to boast. He has to be boastful. He has to show people this is what I have, because he has to protect himself. It's prison. So you put poor, young, and convenient together, and what do you have? You have the perfect scapegoat for the state. This indictment has 28 co-defendants. The prosecutors keep saying, we're trying to clean up the streets of Atlanta. We're cleaning up Fulton County. We're trying to drive crime down. You just heard me say Rodriguez is in prison. The jurors got it wrong in that murder case, and they convicted him. He's going to be there for life. They're not cleaning up the streets of Atlanta. They're cleaning up the prisons. And I promise you, the people in the prison, the wardens, they know how to handle their inmates. They don't need the DA's help. They have it. Out of 65 counts in this indictment that you guys had to listen to, Rodriguez is only in one count. He's only in RICO. That's it. Out of 190 overt acts, Rodriguez has 8 of those acts. 3 of them are for the murder that I've already told you about. 5 of them are survivor posts. He has to do these posts so he can survive prison. So why are me and Rodriguez here? Because the state was to put on a show. Rodriguez is less than 1% of this whole indictment. This reminds me of this anime named Bleach, where it's 16 seasons. Every episode is about 18 to 20 episodes. Sorry, every season is 18 to 20 episodes. And they have season 4 and 5. They have these bouts. They're villains of the whole thing in season 4 and season 5. The main characters are trying to get them out of soul society. You go to season 6, you don't hear about the bounce. You go to season 7, you don't hear about the bounce. Why don't you hear about these important characters? Because they're filler characters. It's a filler season. Me and Rodriguez, we're fillers. We're not integral to the story. They just drag him out of prison to jail to make this bigger than it has to be. We're basically distractions. So as a juror, what can you do to tell the state, we're not going to be distracted? We don't need to listen to filler. You come back at the end of this with a not guilty for Rodriguez Ryan. You tell them we do not want to waste our time on fillers. We just want to get to substance. So I guess sit back, enjoy the show, get some popcorn, because this is not justice, this is a circus. Thank you.
All right, who else wishes to make an opening statement? Mr. Apt? All right, go right ahead, sir.
Thank you so much.
It is more important that innocence be protected than it is that guilt be punished. For guilt and crimes are so frequent in this world. That's a quote from the man who wrote into our Constitution what the presumption of innocence means. His name was John Adams. He was the second president of the United States, right after George Washington. Why is that quote important? Why is the presumption of innocence important? Why did that get included in our great Constitution? Because we want to make sure that we don't accidentally send innocent people to prison. Innocent people don't get punished. I have the great honor of representing Diamante Kendrick, who's sitting in the gray vest at council table with me, along with my co-counsel, Doug Weinstein. Doug, stayed up so everyone can see. Also, you'll meet or hear from at times Katie Hingerty. She was here yesterday. She was the tall woman, blonde hair. And the three of us have the great honor and privilege of defending Mr. Kendrick. I've been practicing law here in Atlanta for almost 30 years, exclusively representing innocent people like Mr. Kendrick. He is not guilty. He is not guilty of every accusation and every count in the indictment that the state alleges. Let me say it a third time, just so you're clear. He is not guilty of every single charge against him. He is presumed innocent, as our great Constitution demands. And we won't have to prove anything to you, as the judge told you. The burden will always lie on the state, and boy, is it a high burden, beyond reasonable doubt. Now, it's not a mathematical certainty. The judge, Judge Randall, who's a great judge, by the way, and very smart, and knows the law really well, will instruct you as to all the law. None of the lawyers will. But that beyond a reasonable doubt standard is a tough standard for them to meet. And the evidence in this case against my client is so very weak. The state's not going to be able to come anywhere near the standard required. My client, Mr. Kendrick, grew up here in Atlanta in a tough neighborhood. He did not come from money. He was poor, hungry, deprived, socioeconomically disadvantaged. But he had a loving mother, a mother who's been with him the entire time of this case and will be every day. And she made sure that he had the best upbringing that he could. You heard Mr. Steele earlier talk about the disadvantage of how Mr. Williams was brought up, and my client had a similar upbringing. It was tough. Food, clothing were sparse. But he dreamt of a better life for himself and for his family. And through hard work, through creativity, maybe a little luck and fortitude, he became a very successful musical artist, a rapper. Now, despite Mr. Kendrick's mom's best efforts, he did get into some trouble. And we acknowledge that. We don't hide from it. We don't skirt it. Mr. Kendrick, you'll find out went to prison between 2015 and 2020. So the state is actually winning because during those years, he's locked up. He can't possibly be committing any crimes that they've alleged. You'll also hear that he pled guilty to a crime right here in Fulton County in 2017 while he was locked up. And he admits that wrongdoing. He owns it. He paid his debt to society. But he also worked hard and obtained success in the music industry. And not just for fame or money. Mr. Kendrick did it because he wanted to give back to his community, a community that was disadvantaged. And that's exactly what he did when he got successful. He did tremendous civic duty. You'll hear evidence that he volunteered, he helped coach a youth football team, and he gave back to his community. He gave back because he knew it was the right thing to do. Now the state, and the evidence will show, the state, the police and the prosecution want to use Mr. Kendrick's past. They put it in the indictment. Despite having paid his debt to society, the state is going to use his prior conviction to try to bootstrap these old crimes that he's already paid his debt for to get you, to convince you that he's guilty of these new offenses. They're going to try to get a second bite of the apple, despite the fact that he served his time, that he pled guilty. They want you to find him guilty again because of a debt he's already paid. And that's not right. They can't prove, using actual evidence in this case, the new crimes that they're alleging in the indictment. So they have to get you to pay attention to the old past he left behind. The evidence will show that he is not guilty of the charges in the indictment, and that the police and the prosecution's case is so incredibly weak. But they have to distract you with the old Mr. Kendrick, the Mr. Kendrick that paid his debt and pled guilty and served his time. It's like a bad magic trick. You ever see a bad magician who's like, look over here, while they're picking your pocket? That's the evidence the state wants you to pay attention to. I've been involved in a lot of RICO and murder cases in my career, in almost 30 years of doing this job. But the judge told you, and the prosecution told you, this case is unique, different. Why? It's going to take months. There are going to be hundreds of witnesses. It is massive. It's definitely the biggest case that any of us have ever been in. Maybe the biggest case in the history of the state of Georgia. Why is that? Lots of murder cases, gang cases, RICO cases take 1, 2, maybe 3 weeks to try at most. Why is this case going to take months? I'll tell you why. Because the evidence will show the government has got to drag in hundreds of witnesses to dance around the weak actual case that they have. They've got to bring in 5 experts to tell you what a gang is. They've got to bring in an expert to tell you what an infinity is, an infinity automobile. They've got to bring in dozens and dozens of witnesses that are not going to say, Mr. Kendrick committed a murder. Mr. Kendrick possessed or sold drugs. Mr. Kendrick possessed illegal firearms. They're going to tell you everything under the sun that dances around the facts and hope that after hundreds and hundreds of witnesses, you're either so confused or so worn down that you'll believe the state's theory. If the case were direct and the evidence were true, it wouldn't take long to trial, because they bring to court someone to say, I saw Mr. Kendrick kill Donovan Thomas. They don't have that. And we're going to talk about what else they don't have, but they don't have enough evidence to prove my client guilty of any of these charges. And so to put lipstick on pig, they've got to try and bury you with hundreds of witnesses that won't tell you that my client's guilty beyond reasonable doubt. Why not bring in someone to say, Mr. Kendrick's fingerprints were on a firearm. Mr. Kendrick's fingerprints were on a bag of drugs. Mr. Kendrick's fingerprints were in the Infinity that was used to kill Donovan Thomas. Mr. Kendrick's DNA was present at the scene of the crime. Why not bring in one witness out of the hundreds that you're going to hear from that will just say, I saw Mr. Kendrick do it? Why not? Because it doesn't exist. And our Constitution and our set of laws and our democracy demand more. They demand that high standard. You may not like Mr. Kendrick and any of these other defendants, but we are not here for a popularity contest. We are here to decide something so much more important. And the state doesn't have the evidence to do it. The evidence doesn't exist, not real concrete evidence. The evidence will show that the state is trying to find Mr. Kendrick guilty by association. That's what they want you to believe. Because they want you to find him guilty because who his friends are. The evidence will show that he had friends, that he knew people, that he associated with people. I thought in America, we had freedom of speech, freedom of association in the First Amendment. But the state wants to present evidence to show you that those freedoms are not true, that the Constitution does not matter. They want to present evidence that Mr. Kendrick is guilty by who he hangs out with, the color of the clothes that he wears, the symbols he makes with his hands, and the beautiful lyrics that he writes and sings. Those aren't actual crimes, that's just free speech. And that is what is on trial here, the First Amendment of the Constitution. They want you to look at evidence and say, these people are guilty because they exercise their right to free speech in America. That's not just wrong, it's un-American. Now, the evidence will show you in 2020 that when my client did get out of prison, due to his hard work, his talent, he became a famous rap star. Almost like buying lottery ticket. You know, the chances of a young person going in the music industry and making it are very, very small. But that made him successful. He used his brain, his creativity, and his really hard work to make his family and his mother proud. And the government wants to punish him for that success. They told you in their opening argument to find him guilty because of overt acts. And they had the gall to tell you that those acts didn't even need to be crimes. That's what the evidence will show. That's what the state says the evidence will show. They told you that those overt acts don't even have to be crimes, but you should, as a result, find him guilty of criminal RICO. This isn't a civil trial, this is a criminal trial. And they told you he doesn't even need to commit a crime, that you should find him guilty of a crime. Does that make sense to you? Does 1 + 1 equal 3?
Objection, misstatement, argument.
I stand in objection to that. Ladies and gentlemen, disregard counsel's last remark.
What are the charges against? Thank you. What are the charges against Mr. Kendrick? The first and the biggest is a murder. We've heard a lot about the murder of Donovan Thomas Ray. Now, Donovan Thomas died, and it's tragic, and murder is wrong. The state had the nerve to show you an autopsy photo in opening argument, not because they needed to prove that Donovan Thomas died, but to exaggerate and scare.
Objection, argument, on what the evidence will show.
The evidence will
Counsel stand in objection.
The evidence will clearly show that Donovan Thomas died. We can see that, and it's a tragic occurrence. And my client and his family grieve for the family of Mr. Thomas. We don't think it was acceptable. But my client had nothing to do with that man's death. He died because of a drive-by shooting at a barbershop on January 10th, 2015. And what happens next? The police arrest the wrong group of people. They admit they arrested the wrong group of people. You heard Mr. Sharp and Mr. Steele tell you about Kenneth Copeland and Demetrius Garlington and the others who were arrested for this crime. And the police charged them. And what is the evidence that turned out that those people got their charges dismissed and Mr. Kendrick got charged instead? Are there fingerprints of Mr. Kendrick on anywhere at the crime scene, on the body of Mr. Donovan, in the car that was used, on a firearm that was used? Are there fingerprints anywhere that tie my client to that crime? No. What about DNA? Is my client's DNA anywhere related to the death of Donovan Thomas? No. What about ballistics? Are you going to hear evidence that there was a match between the bullets or the gun used to kill Donovan Thomas that was a gun ever possessed by Diamante Kendrick? No. Are you going to hear from a single witness out of the hundreds of witnesses that are going to be brought here by the state? One. I beg you for one witness to come to court and stand right here on this witness stand and say to you, I saw Diamante Kendrick kill Donovan Thomas. Will that occur? And the answer is resoundingly no, because my client is not guilty, ladies and gentlemen. He's an innocent man, wrongfully accused of a murder he didn't commit. And if that doesn't get you upset, I don't know what will. It makes me angry. Not one witness. There's videotape that the state will present of an Infinity automobile driving by the bottle shop and being used to kill Donovan Thomas. Are you going to hear witnesses that say my client owned the Infinity, rented the Infinity, leased the Infinity, was the rightful driver of the Infinity? Nope. Will you hear or see evidence to the contrary? Oh, yes, you will. Shortly before Donovan Thomas dies, the state has another video of my client getting into, are you ready? A Pontiac Bonneville. Not an Infinity, a Pontiac Bonneville. So, will you see evidence? Will the evidence show that my client is Superman and can fly through the sky from one car to another? No, you will not. He is not Superman. Maybe he's Mr. Spock and he can teleport. You will not hear evidence of his ability to teleport from one car to another either. And yet, the state claims he's guilty of murder. Now remember, you heard previously about a man named Nicholas Robinson, whose real name is Spencer Wright. He came in and told the police, and they made arrests of Mr. Copeland, Mr. Garlington, and others. The state's key witnesses. But you've also heard evidence that Mr. Copeland is a terrible liar and a terrible person in himself. A gang member. Not to be trusted and not to be believed. But that's the state's key witness who says, oh yeah, it wasn't me, it was Mr. Kendrick and others. Why do we know he's lying? Not just because his lips are moving, but because he was one of the people who was originally charged with the murder. How naive does the state have to think you are to not understand that the incentive for Mr. Copeland to lie is as simple as, I'm charged with the murder. If I say someone else did it, then I don't get charged with the murder. It's a ridiculous theory that they have, quite frankly. And the evidence is so super thin and super weak, it reminds me of nothing more than a Krispy Kreme donut. Thin air. In fact, Mr. Garlington, when he's interviewed by the police, says, yeah, I don't know who killed Donovan Thomas. They have no way to corroborate it. They have no actual evidence. The state wants you to buy into this theory of murder. and our Constitution demands you don't. They charged a bunch of people, the police, the Atlanta Police Department, figured out, oh, we messed up and got it wrong, but now we're going to charge a bunch of other people. But trust us this time. Does that imbue trust to you? Is that evidence that you'll hear about that seems trustworthy? No, it is not. That evidence is completely untrustworthy and unbelievable and unreliable. It's a bad magic trick. No fingerprints, no DNA, no witnesses, no ballistics, and videotape that actually exonerates and proves that he's not guilty. Krispy Kreme donut hole. What's the next charge against my client? Well, there's a bunch of them involving guns. And 3, to be exact. One is that he's charged with possession of firearm during the commission of a felony. If you're committing some other felony and you're using a gun, you get charged as an extra charge. The second is possession of a machine gun. Ms. Love described to you, Mr. Steele described to you what a fully automatic weapon is. Pull the trigger once, all the bullets fly. That's illegal. And the third is possession of firearm by a convicted felon. Yes, Mr. Kendrick's a convicted felon. So he's not allowed to possess a gun. And he knows that. And again, the indictment. We've talked a lot about the indictment. You're going to get it. It's a document. It's a long document. But the indictment charges my client with those 3 firearm charges, all stemming from one date, March 9th of 2022, the date that Mr. Kendrick is arrested. So what happens on March 9th of 2022? He's at a house owned by Jeffrey Williams, his friend and colleague, who he's made beautiful music with, wonderful music that's entertained millions of people. And at that house, and there's dozens and dozens of people at this house on the night of March 9th of 2022. It's not like there's 2 or 3 people there. Dozens. And there are guns in the house. So, how do we get to firearms being in the house to Mr. Kendrick possessing firearms? We don't. We don't. There's not going to be a single piece of evidence showing that Mr. Kendrick's fingerprints are on any of the guns. There's not going to be a single piece of evidence showing his DNA is on the guns. And quite frankly, you'll learn, and the evidence will show, there's something called touch DNA. What is that? You're going to learn that if I touch this table, and my hand is here for a couple seconds, I don't just leave my fingerprints behind, I actually leave some of my DNA behind. And that can be tested, forensically tested by the police and by the GBI lab and the state of Georgia. So there's no fingerprints on the guns that belong to DeMonte Kendrick. There's no DNA. There's not a single person at the party or a single witness who says DeMonte Kendrick had any of these guns. No one is going to say he bought any of the guns. No one's going to say he sold any of the guns. No one is going to say he possessed any of the guns. But they're going to want to do a dirty magic trick and show you his past. He pled guilty to a gun offense years ago. And so he must have been possessing the guns. That's their theory. Assume and speculate to find him guilty. That's not what we do in this country. That's not what we do in a democracy. That's not what we do with our Constitution. And that's not what we do when someone's presumed innocent and has to be proven guilty beyond a reasonable doubt. One witness, please, that says DeMonte Kendrick was holding a firearm that night. DeMonte Kendrick bought one of the guns. DeMonte Kendrick used one of the guns. No one. No one's going to testify to that. And why is that? Because he didn't have any of those guns. He was at a house where there were guns. That doesn't mean he was in possession of illegal firearms. You could go to a party where there are 50 people, somebody has guns, you don't know about it, maybe you do, but it doesn't mean you're possessing the guns. That's what the evidence is going to show. He was there. It could have been a bazooka in that house. I don't care. Mr. Kendrick wasn't in possession of any firearms, illegal, machine gun, or otherwise. He didn't control a gun. He didn't use a gun. He didn't buy a gun. He didn't sell a gun. He didn't hold a gun. Not one witness. And there are dozens of people that they could call to say, oh yeah, I saw Mr. Kendrick hold a gun, but not one. And there could be hundreds of witnesses. I want to bury you with witnesses so that you'll forget about the presumption of innocence and what real evidence is required. Zero, not zilch, donut hole, reasonable doubt. What will they show you? What will the evidence show that night on March 9th? Well, they'll show that Mr. Kendrick was afraid. He's a black man in America, and there's a team of people swarming a house with firearms. He's not sure if the police or not. But in 2022, after COVID, BLM riots, people like George Floyd died, he had a reasonable and healthy fear, fight or flight. Mr. Kendrick doesn't want to fight. He doesn't want to fight the police, and he doesn't want to fight people who aren't the police if they're armed. But he knew that there were people swarming the house with guns, and it turned out they were the police. So what did he do? He ran. He did the absolute smart thing to save his life. He was afraid, and he ran. And the police caught up with him shortly thereafter. Now, he's not charged with fleeing the house. He ran because he was afraid, and that's a reasonable thing to do for him. Given how he grew up, where he grew up, and the state we live in. And when the police caught up with him, just shortly thereafter, did they find him holding an FN, the type of gun Ysl described? Did they find him holding a strap machine gun? Did they find him holding a Glock? Did they find him with an AK-47, an AR-15, or any other kind of gun? No! He was unarmed because he never had a gun. There's not a scintilla of evidence that you should believe that Mr. Kendrick is guilty of any of those 3 firearm charges. Not a scintilla. Hundreds of witnesses. I asked for one to come to court and say, Mr. Kendrick was holding a gun that night. What about the next set of charges? They're drug charges against my client. But all the drug charges against him, possession of cocaine, possession of coke, all the drug charges alleged against Mr. Kendrick are again from March 9th of that year. From the date he was arrested, the party at Mr. Williams' house. And apparently the police find drugs in the house where there are dozens and dozens of people. So again, I ask you, listen to the evidence. What will the evidence show? Will the evidence show my client's fingerprints on a bag of drugs? No. Will the evidence show my client's DNA on a bag of drugs? No. Will a witness come to court and tell you he was using drugs that night at the house? No. Is there videotape of my client snorting a line of cocaine? No. Is there going to be a witness who tells you that my client sold him drugs? No. Is there a witness that's going to tell you that my client bought drugs? No. Is there going to be any evidence that my client possessed used, bought, sold, controlled drugs on the night in question? Absolutely not. There were drugs at the house. My client was at the house. There are dozens of people at the house. 1 + 1 does not equal 3. It's another Krispy Kreme donut hole for the prosecution. Zero, nada, zilch. We're not going to hear evidence that my client's blood or urine was tested and that it was in his bloodstream there was cocaine or other drugs. And the indictment says that the drugs that they're charging him with are from that date, March 9th, 2022, the day he was arrested, not any other day in his life. So the question you have to ask, the evidence you have to look at is he possessing drugs while he's at the party at that house? And there is no evidence of that, just like the guns. The next charge against my client is gaming activity. And the gang activity they allege, very specifically in the indictment, it's not just any gang activity, it's gang activity related to the possession with the intent to distribute illegal drugs from March 9th of 2022. And again, where is the evidence? Not one witness. They also allege that he committed gang activity based on the guns. Same thing. There's just no evidence of it. It is not illegal to be part of a group in America. Freedom of association. Otherwise, the Atlanta Falcons would be an illegal street game because they wear red and black and they have certain symbols they wear. And the Braves, certainly the Braves, because they lost in the playoffs. Maybe the state of Washington would like that. It's not illegal for my client to want to wear the color green and do fancy symbols with his hands. But they're going to bring dozens of witnesses in to talk about that. So what? That's not a crime. Illegal gang activity requires my client to have committed a crime and be in a gang. And YSL is not a gang, but we'll get to that in a minute. They want to attack free speech and freedom of association. They're guaranteed to us in the Constitution. And if they want to do that, then they should go out and arrest the Falcons and the Braves too. Not one witness is going to come to court and say, Mr. Kendrick possessed, sold, bought, used drugs as part of gang activity. Or possessed, sold, used a firearm as part of gang activity. I want you to tally, keep counts, take notes. How many witnesses the state brings in this case? Hundreds. And I want you to remember this conversation I'm having, this one-sided conversation I'm having with you all. About how many witnesses say, my client possessed a firearm because he was a YSL gang member. My client possessed drugs because he was a YSL gang member. What is YSL? It's a successful, massively, worldwide, internationally successful record label. And my client was a part of that record label and a successful rapper and blessed with the ability to make that music. And last I checked, those lyrics, which the state is going to try and use, are just part of free speech. So we've eliminated murder, we've eliminated the gun charges, we've eliminated the drug charges, we've eliminated gang activity based on gun or drug charges. So what's left? What's left is count one, RICO. I told you, that's a term that most normal people don't use for good reason. It's a very complicated legal term. Most lawyers don't even understand it. I'm going to try to explain it to you. And you've heard a lot about overt acts versus predicate acts. Are you confused already? You should be. They want you to believe, and they want the evidence to show, that Mr. Kendrick is guilty of this vast conspiracy because who his friends are, who he hangs out with, the colors he wears on his clothing, and the lyrics that he writes, the rap music that he makes. And they suggest to you this is all part of a vast conspiracy. But the reality is, some of these lyrics may be offensive to you, and that's okay. Because in a free society, we have free speech. That doesn't make it a crime. The state says that the evidence will show that they dug to find out the murder and then used the lyrics to support it. You know, I watched Goodfellas. It was a movie about real crimes that took place. It was written by Martin Scorsese and acted out by Robert De Niro. The DA's office is going to go arrest Mr. Scorsese and Mr. De Niro. They're exercising their free speech to tell a story. Why can't my client, Mr. Williams, do the same and write lyrics about crime? Maybe they're offensive. Maybe the movie Goodfellas is offensive because you see people committing crimes. But in a free society, we're allowed to exercise free speech. It's the price we pay to live in a free country, and it's a great price. Just because someone raps about murder or other crime does not make it a crime. Why do they rap about that stuff? Because it sells records and it allows them to creatively express their feelings about how they grew up and where they grew up. And they are proposing a war on the First Amendment of freedom of association and free speech. They don't like those lyrics. They want to send a message to all those inner city kids in Atlanta who dream about getting out of the ghetto and becoming successful musicians. And their message is, you rap lyrics about crime, we're gonna indict you and charge you and brand you a criminal. That's un-American. That's wrong. The evidence will show that the state of Georgia and the city of Atlanta have been blessed in the last 20 years by the entertainment industry. And not just rap music, TV and film, and all kinds of entertainment. And some of it's fictional. And that's okay. It's okay to rap about crime or life or your experiences, even if it's not true, even if it didn't really happen. That's just free speech, ladies and gentlemen. That's not evidence of a crime. That's protected in our Constitution. It's a protected part of living in a free society. YSL was a very successful record label, and there's going to be evidence of that. It made millions and millions of dollars. That's not a criminal street gang. But it's not just a successful record label. It gave my client the opportunity to give back, to volunteer his time and some of his money. He coached an inner city youth football team. Does coaching that inner city youth football team support their RICO accusation? Because they told you the overt acts don't have to be a crime. Maybe now we should criminalize civic volunteer work. I don't know where it ends if we start making free speech illegal. They want to lump Mr. Kendrick in. They want to have you find him guilty because of other people's crimes or crimes that he already paid his debt to society for. So the state presented you some of the examples of that. Will Wayne's tour bus got shot up. That's horrible. Whoever did that should be punished. But there's no evidence my client was there to pardon it. They're alleging that's part of this case. The shooting of Chanel Drakes you heard about, gunned down in a rental car. But they're not alleging Mr. Kendrick took part in that either. And what about the attempted stabbing of Rayshawn Bennett, Wyatt, who's known as Wyatt Benucci, another rapper, and the armed robberies they alleged? None of those incidents involve Mr. Kendrick. But what they're going to argue to you is that if Mr. Kendrick was part of the YSL label, or what they call the YSL gang, then even if he's not charged with those crimes or involved in those crimes in any way, he should be found guilty of RICO conspiracy, even if he didn't commit a crime. And that's wrong. It's just wrong. That's why they have to go to such great lengths and bring hundreds of witnesses in to establish other crimes, other acts, other incidents that my client had nothing to do with. It's a bad magic trick. Look over here at Will Wayne's tour bus. If they actually had evidence of my client committing a crime, we'd be here for a week, not months. The conspiracy they want you to criminalize is being a rapper in America and being successful. They want to attack the First Amendment. They want to attack free speech. They want to attack capitalism because they don't like rappers who rap about criminal behavior in Atlanta. And they're telling you that this is a pattern of activity, a trend to attempt to control and exert influence. But really what they're showing you is, if we don't like your speech, then some free speech is wrong and illegal. And you should find my client guilty as a result. They don't want you to find Mr. Kendrick guilty based on his actual actions, just based on the words he wrote and said. They don't want you to find Mr. Kendrick guilty of his actual actions because they don't have the evidence of it. They don't have the evidence of a murder or illegal guns or illegal drugs. They don't actually have that. So instead, they've got to play their bad magic trick. But you're smart and you can listen to the evidence and you will see it's nothing but a Krispy Kreme donut. That's what the evidence will show. You heard about wiretaps. It's basically the police listening in on people's phone conversations. And that's fine. They get a judge to approve it, they're allowed to do that. And there's hundreds and hundreds of hours of wiretaps. And I dare you to listen to all that over the next few months and hear one time my client saying, I have a gun, I have some drugs, I committed a murder. It doesn't exist. Nowhere. I'm part of the YSL gang. Remember, they told you that the YSL is this sophisticated gang, so there's no written agreement, there's no verbal agreement. It's just something you have to trust them with. Does that sound right? Just trust them. Take the government's word. And they're going to bring in experts on gang activity to tell you that the record label is a gang because they think so. Well, they work for the state, for the police. They're going to tell you what they want you to hear. But use your brain. Use your common sense. All those wiretaps you're not going to hear Mr. Kendrick say one time, I'm going to do something illegal. Whether it's a violent crime, a gun crime, drug crime, or admitting he's part of a gang. Not once. In hundreds and hundreds and hundreds of hours of wiretaps. And why? Isn't you all hear that? Because what is he actually? He's a former convicted felon, a former gang member, and a current recording artist, a current rapper with Ysl, and a current member of society doing civic duty. They have to point at his past and get you to only look at that, because the actual evidence from March 9th and from January 10th, the 2 dates in the indictment that accused my client, there's no evidence of him committing a crime. The state turned over to us, prosecution, 6 terabytes of data in this case. Now, I'm not a computer expert, but I want to talk to you about what the evidence will show. A lot of that evidence you're going to hear and see. What is a terabyte? It's an enormous amount of computer data. And here's what I'll sort of tell you the analogy is. If it were pieces of paper, 6 terabytes would be 420 million pages of documents. 420 million pages. That's how much evidence there is in this case. Is there one page? Is there one witness? One set of fingerprints, one set of DNA, one videotape that shows my client committed a murder, that shows my client possessed illegal drugs, that shows my client possessed a firearm, that shows my client committed illegal gang activity, or that my client conspired with others to commit crimes? It's a donut hole. It's a Krispy Kreme donut hole. You don't get the glaze, you don't get the donut, you just get the air in the middle. What did Mr. Kendrick do? Oh, they have pictures of him flashing gang signs and wearing green. They have pictures of him standing on the hood of Rayshawn Bennett's car at Lenox Mall. Oh, God forbid. He stood on the hood of another rapper's car, and they want you to believe that is the evidence that he's part of this vast conspiracy. No. Standing on someone else's car, it's a nice car, is juvenile. It's silly. Maybe it's even a misdemeanor. But they didn't charge him with that misdemeanor. Instead, they charge him with a RICO conspiracy. Standing on the hood of this other rapper's car must be proof that he's part of this vast conspiracy they're alleging. Quite frankly, the real juvenile behavior is all these hundreds and hundreds of witnesses to try and prove something that doesn't exist. There are lots of other overt acts, and I'm not going to belabor each one of them to you because you heard most of them from Mr. Steele and from the state. But you've also heard from me. If there's a witness who says Mr. Kendrick possessed a firearm or possessed illegal drugs or murdered Donovan Thomas, they saw him murder Donovan Thomas, and bring that person to court. Mr. Copeland, their star witness, is going to come to court and say that Mr. Kendrick admitted to him, Mr. Copeland, that he was part of the group that killed Donovan Thomas. You going to believe Mr. Copeland, who has every incentive to lie? That's the evidence they want to rely on? That's what they're keeping here? That's here for months and months. The guy who was charged with the crime, who now says it's not him, it's my client instead. Please tell me there's something better, something else that we're here for. Please tell me we have anything near proof beyond a reasonable doubt. We don't. There's no real or concrete evidence my client committed a crime. Not a single offense. Not RICO, not gang activity, not guns, not drugs, and definitely not murder. Ms. Love talked about the wolf pack. I understand that. She thinks the evidence will show that. But I really think it's more like the boy who cried wolf. You know that old story. There's a wolf, there's a wolf, there's a wolf. And it turns out there wasn't a wolf. And that is why you will come back many months from now and find my client, Mr. Diamante Kendrick, not guilty on every single count. Thank you.
Mr. Harvey, wish to make another statement this time, sir?
Judge, on behalf of Mr. Nichols, Ms. Westmoreland, and Mr. Gardner, we would reserve our opening statement under Uniform Superior Court Rule 10.2 until the completion of the state's case.
So noted, sir. All right, Mr. Matthews.
Yes, sir.
All right.
Thank you. Good afternoon, ladies and gentlemen. Yes, just need to stretch anything. My name is Carrington Matthews, Sr. Attorney Teresa Mafood and Attorney Carrington Matthews, Jr. We have the pleasure and the honor of representing Mr. Marquavius Huey in these proceedings. Who is Marquavius Huey? Marquavius Huey is 27 years old. He is 27 years old. He was born and raised in Atlanta, Georgia. Born and raised in Jonesboro South housing projects, as you have heard about over these last several hours throughout these various opening statements. He has 6 other brothers and sisters, and he actually graduated, ladies and gentlemen, from South Atlanta High School in 2014. He has 2 children. He has a 4-year-old son, Major, and a 1-year-old daughter, Journey. Mr. Marquavius Huey is not a convicted felon. He can sit on a jury. He can own a firearm. He can vote. And he can do what abiding citizens can do as a non-convicted felon. He has goals, ladies and gentlemen. He has goals of being able to one day open a store, a retail store that sells men's and women's clothing. It's one of his goals. And when he grew up in Jonesboro South, ladies and gentlemen, he grew up with various folks that live in that community. As any community that you live in, you gain friendships and you grow up together. And Mr. Huey, he grew up with Jeffrey Williams. They were friends from childhood. That's what the evidence will show. You will learn it. Now, let's get into the overt act 76. This is a theft by receiving of a handgun in 2018. That's one of the overt acts in this case, ladies and gentlemen. Now, in that particular indictment, back in 2018, that actual indictment was brought by the Fulton County District Attorney's Office. They brought it in 2018 against Mr. Huey. Also in 2018, they reduced it to misdemeanor disorderly conduct. They gave him 12 months probation, and they agreed to that reduction. This table, this organization, this agency, in 2018. Now, in 2018, they reached that agreement with Mr. Huey. Now here we are in 2022 when this case was indicted, and now in 23 when it's being heard, they're using the same charge that they initially charged him with, of theft by receiving of a handgun. They reduce it down to a little misdemeanor, disorderly conduct. And now they say, hey, let's tell the ladies and gentlemen of this RICO trial that this is an overt act in a RICO conspiracy in a YSL case. That's what they have brought to you in this indictment. The evidence will show that in 2018, this had nothing to do with anything concerning RICO. Because the evidence will show, had it, now keep in mind, the date 2013 to even the present is what the government just told you all yesterday, was this RICO conspiracy. So in 2018, ladies and gentlemen, if this particular overt act has anything to do with a RICO conspiracy today, why did the same agency decide in 2018 that a felony theft by receiving charge negotiated, agreed to, should get reduced down to disorderly conduct? But this is what the evidence will show. You will learn it, and this is what's been handed to you. Now, let's break it down. This indictment. Counts 3 through 7 we're going to go through first, and then we're going to go through another grouping of counts. But these are there are a lot of charges in this indictment with respect to Mr. Huey. There are a lot of charges, right? But when these charges are put together the way that they are supposed to be, you will see as we get through this case that there are two cases that we're dealing with in these groupings concerning the Fulton County Jail. So just stay with me. We're going to get there. Let's first talk about April 26th, 2019. These are counts 3 through 7. Count 3, Overt Act 88, Mr. Huey is charged with armed robbery. They're saying that on April 26th, they're alleging that Mr. Huey, as a party to a crime, committed this armed robbery against this gentleman by the name of DeJuan Maynard. That's what that particular count talks about, an armed robbery, using a firearm with an unknown person to take these items from this person. We're going to get into details, but I'm going to go over the charges first. Count 4. They are charging Mr. Huey with Overt Act 89, aggravated assault, saying that with that same firearm that Mr. Huey pointed the weapon at Mr. Maynard as he took the items, and that this makes up an aggravated assault. That's the charge. Going over the charges, then we're going to get into what the evidence is going to show. That's count 4. Count 5, the same one case we're talking about, the same one grouping, aggravated assault, because there was this other individual by the name of Damon Jenkins who was with Mr. Maynard. So they have charged Mr. Huey with this ag assault on the Damon Jenkins. Same grouping, same incident, April 26, 2019. And then count 6 are these charged with an armed robbery. You're going to get an ag assault. You're going to get a possession of a firearm during a commission felony. That's how the government, that's how they indict cases. Those are the charges. We'll get into all that later, but these are the charges. We'll get into that at a different stage in this trial. But that's count 6, saying that Mr. Huey had in his possession this firearm when this alleged incident happened, where they are claiming that Mr. Huey was involved. We're going to get into it. And then 7 is that same gun charge against Mr. Damon Jenkins. So that's 3 through 7, ladies and gentlemen. April 26, 2019. So what happened? Let's get into it a little bit. April 26, 2019, around 12:39 a.m. in the morning, at 741 Morosco Drive, Northeast, Atlanta, Georgia, at this apartment complex called Core Lindbergh Apartments. That's a stock photo of that particular complex. Now, here's the story. The story is that, and we're not disputing that this incident happened. We're disputing that Mr. Huey is ever a part of it. Mr. Huey stands before here. He signed an indictment and indicated that he is not guilty and he is innocent of these charges. And we stand here straight and we look you in the eye and we stand tall that Mr. Marquez Huey is innocent. So, April 26, 2019, you've got 3 individuals. They have left the apartment unit, and these 3 individuals are walking in the parking deck, right? They're walking to their car. 3 individuals. As they're walking to the car, these 3 individuals, they see 2 black males get out of a vehicle. They describe it as a black Mustang with a temporary tag. So these 3 individuals, they're in the parking deck, they're walking to their car, and 2 other individuals get out of the car, and they begin to chase these three individuals. There's video surveillance in the parking garage. You will likely see this video surveillance. It's the government's case, and they get to present their case however they choose. If they choose to show you a video, you will see it. Right? Now, let's talk about these three individuals that are walking from their apartment to their car. Damon Jenkins, he lives there. He knows the apartment complex. He knows the parking deck, right? So he lives there. He's familiar with his spot. He's familiar with his crib, right? So he runs down the parking deck. So he sees them. He's walking. He sees them. He goes down. So he goes essentially left. Okay. That's Damon Jenkins, the apartment lessee, the owner of the apartment, his crib. DeJuan Maynard. DeJuan Maynard is with Damon Jenkins, right? What does he do? So he's visiting his friend, Damon Jenkins. Damon Jenkins has the keys to Maynard's vehicle. Maynard is the one with the jewelry and the items, right? Maynard, he goes right, and he goes up the parking deck, right? And he's running. Now, you've got this armed robbery that is occurring. You've got Damon Jenkins going left, down the deck. You've got Maynard going right, up the deck. Now, pay close attention. The two perpetrators, they decide that they are going to go after one person, not two, right? This is an armed robbery, right? You've got two perpetrators, you've got three victims. One of those victims goes left, Jenkins, Maynard goes right. Maynard is the one person out of those three that those two perpetrators go after. So you've got two individuals that are the perpetrators chasing Maynard up the parking deck. The third male, I guess he goes down and he is not chased. He goes down, one goes left, he ducks, the other one, Maynard goes up the deck, the two perpetrators chase Maynard. That's the story, that's how it's happening. Now, the two perpetrators, they reach Maynard. When they reach Maynard, ladies and gentlemen, Maynard, he says when he got hit with, one of them hit him with the firearm, and that they took items. Now, these are the items that Maynard says were taken. This is what he says were taken. He says a ring, a diamond 5-point star ring. He says 2 gold chain necklaces, one with a cross, another with diamonds, 1 pair of diamond earrings, a gold Gucci bracelet, a SunTrust debit card, a Gucci bag, a Louis Vuitton bag, and some cash. So you got all this grouping of items that Maynard says that was taken from him. You've got police officers galore that come over to the scene, right? So you've got responding officers, you've got white shirt officers, you've got sergeants, everybody responding there, trying to figure out what happened. They talked to Maynard and Jenkins, right? They talked to the security guard, Joel Hines. Joel Hines, he says that, I was patrolling the area. I saw this black vehicle had been parked and running for about an hour or so. It had tinted windows, and I couldn't see inside. And, apartment owners, sometimes they'll come sit in their apartment in their cars before they go inside, so I didn't think anything of it. I didn't see anybody. I didn't get a look at anyone. So the security guard, he doesn't see any individuals that are in the black vehicle. They canvass the parking deck. The officers, they get surveillance videos from the parking garage. So that's what the officers are doing. That's what they did that night, right? Now, here's where it gets interesting, ladies and gentlemen. On April 26, 2019, at 12:39 in the morning, that's when this incident happened. Demond Jenkins, when he goes left, Demond Jenkins, who's the apartment owner, when he goes left, he goes downstairs, he runs out, and he happens to see an officer, he flags him down. So that officer's right there, pretty much. All right? And then other officers start coming and converging on this incident scene to try to figure out what happened. But on that same day, later that day, Maynard, the one whose items he claims were taken, he does this, I don't know if he does an internet search, what he does. How in the world of millions of social media people that are on social media, Instagrammers, people that have pages, Maynard calls into zone 2 and he tells the police that he just happened to be scrolling Instagram and he saw a person wearing his diamond 5-point star ring. Imagine that. Less than hours. So what does he do? Maynard calls in. You will hear evidence that when he calls in, that he sends some photographs. I'm going to get to that. So the case is assigned to Detective Jeffrey Henderson on April 28, 2019. So the case now has a detective. A couple days later, Detective Jeffrey Henderson now has this case. What does he do when he gets the case? Well, he gets Maynard to send him these photographs. He views the video surveillance footage that he obtained from the parking deck, from the apartment complex. And he asks him to send some pictures of the jewelry. So send this information that you found on Instagram, send me some pictures of your jewelry, and send me some videos, and let me take a look at the video surveillances that I was able to get from the parking deck. So these are the photographs that Maynard, the victim in the case, he sends Detective Jeffrey Henderson 2 separate Instagram pictures of 2 separate people. On the left there is a picture he sends of someone else, some person in the world on social media. Maynard sends that photograph, and he sends the one on the right. The one on the right is Mr. Huey's Instagram. The one on the left is someone else's Instagram. He sends these to Maynard, to the Detective Henderson. 2 different people with the same ring, or the similar ring, or some ring that looks like the one that he owned the same day. So he becomes his own detective. Now, the video that was obtained from the parking garage, ladies and gentlemen, that video it shows the two perpetrators running after Maynard, right? One of those perpetrators has on like a black jacket and maybe some red pants or something of that nature. The other person has on a gold puff jacket and some black slacks, pants or jeans or whatever. So that's what the video is showing from the parking garage. So what does Detective Henderson do? So he goes on to Mr. Huey's page, and I guess starts scrolling Mr. Huey's page. Oh, Mr. Huey has a gold puff jacket. But guess what, ladies and gentlemen? In this particular, Mr. Huey's is on the right, standing in front of a black Infiniti vehicle that belongs to his lady, Justice Woodard, who is the mother of their two children, Major and Journey. On the left is a photograph. You heard Mr. App talk about that huge discovery that was sent to us. The evidence will show that that particular photograph is part of the discovery that came to us in this pile of evidence that is a part of this case. That on the left are two young men. And what's interesting here, ladies and gentlemen, is that apparently that year, the gold puff jacket from Zara was a very popular item for young people as part of their wardrobe. We know that because you're going to learn that this is what was sent to us, and that is what was going on with the dress back in 2019. 3 different people with the same gold puff jacket that was provided to us in discovery, that the government provided to us. So the gold puff jacket is relevant here. Why? Because what was Detective Jeffrey Henderson's investigation at that point? Maynard sends him these 2 hands with dissimilar jewelry. Maynard sends him a piece of jewelry of his own to say, hey, you know, this is what was one of the items that was taken from me. And the video, ladies and gentlemen, from the apartment complex shows a person with that similar gold puff jacket. And what does Detective Jeffrey Henderson do with that information, ladies and gentlemen? He completes it. He completes his investigation. This happened on April 26, 2019. 4 days later, he was arrested. On that investigation, that is the case. Now, there is no photographic lineup that was ever done. Maynard never says he saw Mr. Huey that night on April 26, 2019. They're not wearing masks. Mr. Devon Jenkins never selects Mr. Huey out of any photographic lineup. In fact, there was none done. There was no photographic lineup performed or attempted to be performed by Detective Henderson for the benefit of Maynard or the benefit of Jenkins in this case. He took what he got from that video surveillance, went on to receive the information that Maynard sent him, and decided that there was enough for a warrant. No photographic identification, no fingerprints left at any of those scenes, no shell casings that are linked to any firearms belonging to Mr. Huey. None of it. That's what you're going to learn. You're going to learn, ladies and gentlemen, that at any arrest that was made against Mr. Huey, any arrest that was made against Mr. Huey with respect to these items that Mr. Maynard says were taken from him, a gold 5.5 star ring, these necklaces, these items that we're talking about here, the Gucci, the Louis Vuitton, the debit cards, none of those items have ever been found on Mr. Huey's person, on Mr. Huey's any car, in any residence. None. That's the state's case for those grouping of charges, ladies and gentlemen. No DNA. Detective Henderson didn't even, when they arrested Mr. Huey for those particular charges, those groupings of charges, he didn't come down to the jail and even pull him out of the cell and say, hey, I want to talk with you. Are you willing to talk with me? Of course, that's Mr. Huey's right to either talk to him or not talk to him, but he didn't even try. No other witnesses out there at that location that are going to tell you that they ever saw Mr. Huey at that location. That's what you're going to learn about that grouping of cases. No photographic lineup. Ladies and gentlemen, this is interesting. Listen to me very closely. You will not hear any evidence of a cell phone tower locating Mr. Huey at 741 Morosco Drive, Northeast Atlanta, Georgia. You will not hear it. In the technology-driven world that we live in, cell phone evidence is powerful in terms of being able to put people at locations. Ask me, did Detective Henderson make any efforts to do that? You will learn the answer is no. Okay, that was that grouping of cases, ladies and gentlemen. Okay? That was that case from April 26, 2019. Okay? Now let's move on to this other grouping of cases that we just, that I want to talk about now. So let's move on to another time and another place. Let's go to October 1st, 2020. Now, count 14, when you all get this indictment, count 14 over Act 116 charges Mr. Huey with armed robbery, alleging that Mr. Huey and another unknown person committed an armed robbery against a gentleman by the name of Gary Holloman. That's what count 14 says, by use of a firearm. That's 14. 15, we're still on October 1, 2020. These next series of counts are going to deal with one day. This particular count, 15, armed robbery, says that on that same evening that Mr. Huey, along with this unknown person, committed this armed robbery against Domisha Coppage, who is out there with Gary Holloman at an address that we're going to get to in just a moment. But I want to go over the charges first, and we're going to get into the facts in a moment. So that's the charge right there. Count 15, an armed robbery concerning Domisha Coppage. Count 16, this is a big case, ladies and gentlemen, so I'm giving you an opportunity to try to organize it as best you can. Because we definitely have been learning all year how to organize a big case. Count 16, aggravated assault with a deadly weapon. Like I said, whenever there's this armed robbery allegation, it's going to come with a host of other counts and charges tagging along with it. Because that's the way the state and government, that's how they do it. That's how they get down, and that's how they do it. That's their right, and that's how they want to bring it. But we're going to talk about it. Count 16 alleges aggravated assault. So whenever you commit an armed robbery, then you've got a firearm, then you're going to get an aggravated assault charge with it. That's the aggravated account charge that deals with Gary Holloman. That's 16. 17 deals with Domisha Coppage. 18 is another way of alleging an armed robbery. When you specifically use a firearm to take this clicker out of my hand, that's armed robbery. But if this clicker were an automobile, and I was sitting in this automobile, and you use a weapon to demand me to get out of the automobile, it's an armed robbery, but they call it, it's a separate charge that's called hijacking of a motor vehicle. Basically, it's an armed robbery of a car or a truck or a vehicle. That's count 18. They're saying that Mr. Huey, along with this other person, took a 2016 Buick LaCrosse from Gary Holloman. That's 18. 19, again, whenever there's a weapon that's involved, they're going to tag along this possession of a firearm to the commission of, in this case, the ag assault with a deadly weapon and the hijacking of a motor vehicle. So you're going to get a possession of a firearm during a commission of a felony charge. Same thing with respect to Ms. Coppage. Armed robbery and an aggravated assault to take that cell phone that she's saying was taken. You're going to get a count 20, a possession of a firearm during a commission of a felony. And then what they've done is they've said in 21 that this was gang related. So they tack on a criminal street gang charge. And the same thing for Ms. Coppage. So those are the street gang charges that they've alleged. That's 23. So let's get into it now. So those are the charges, ladies and gentlemen. On October 1, 2020, 250 Fulton Street, Southwest Atlanta, Georgia. Not very far from where we are now, over by the juvenile court building. They're alleging that on this particular October 1, 2020, in the evening hours, that these charges that we just talked about occur. Now let's deal with it. What is being alleged here? Gary Holloman, who's no longer with us, ladies and gentlemen. Gary Holloman sold pills for a living. He was a drug dealer. And Mr. Huey had gotten injured. And his injury was the result of a shot to his leg and being out in the public and living in the area, there was a shooting incident. He got shot. Okay? When he got shot, he ran out of the ability to get medicine the right way. So what did he do? He found that this guy Holloman that he knew through this other person, Mender, that Mr. Holloman sold Percocets. So what happens? He had been dealing with Mr. Holloman for some period of time. You're going to hear about it. And how do you know you're going to hear about it? Because when Detective Henderson comes into this courtroom and sits in this witness stand, I'm going to ask him questions about it. Now, Huey knows Gary Holloman because they had been doing business. Mr. Holloman purchased 2 or 3 pills periodically, $20 a pop, Percocets. And he dealt with Holloman various occasions. Nothing unusual. I'm gonna meet you. I'm gonna call you, right? He calls him. Huey calls Holloman from time to time, right? And when he calls Holloman from time to time, Holloman, in fact, you will learn through Henderson that Henderson, when they arrested Mr. Huey on these charges, they sit Mr. Huey down in an interview room. And when they sit Mr. Huey down in an interview room, Henderson reads him his rights. And Mr. Huey agrees to talk with him without an attorney. Because I don't have anything to hide. I'm okay talking to you without a lawyer. He sits down, talks to him. And Mr. Huey, he didn't know specifically why he was even being arrested at that moment. And you'll hear about it, right? And when you hear about it, Henderson is saying, hey, somebody's saying that you carjacked him. Okay. Tell me about it. What are you talking about? And then Huey and Detective Henderson, Huey says, okay, so you're talking about the street's been talking. The street's been talking. They saying that I set Holloman up. They saying I set Holloman up. I didn't set Holloman up. I deal with Holloman. I didn't set this man up. Holloman chose this particular location for us to meet, and we've met before. I know this man. In fact, now here's where it gets real interesting. In fact, Huey says to to Henderson, Detective Henderson, you can look through my phone. So, Henderson looks through the phone. And what does he see, ladies and gentlemen? He sees a...
Your Honor, we're going to object to this portion of
Basis.
self-serving hearsay.
Yes, the evidence will show.
I'll overrule the objection.
The evidence will show, ladies and gentlemen, that Henderson, they have the phone out. Huey is leaning over. Henderson has the phone. They're scrolling. Okay. 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 But The warrants had already been written up. He was in jail. He was arrested that night. He was being arrested for it on the 24th of November, 2020. But Mr. Huey shows Mr. Henderson that he and Holloman had a relationship. You got something I want, you got something that I want to get, some Percocets, they're available. That was our relationship, right? Now, that's what Huey says to Henderson and is corroborated in a phone that belonged to Mr. Huey that Henderson was allowed to look at on that particular morning when they arrested this man. So that's what came out from Mr. Huey. Let's talk about what came out from Mr. Holloman when he called 911. So what does Holloman basically say in the 911 call? He says that I just got robbed, and he says my nephew homeboy robbed me. My nephew's homeboy robbed me. That's what he says. And I was meeting with him because my nephew wanted me to give him some money to put on my nephew's books at the Fulton County Jail. That's what Holloman says to 911. Now, you're going to ask yourselves, ladies and gentlemen, the evidence is going to show that you don't need to give money to your nephew's homeboy to put on your nephew's books at the Fulton County Jail. The evidence will show there are many ways in which you can put money on somebody's books at the Fulton County Jail instead of giving money to your nephew homeboy. So, you are going to have to reconcile that story that my man Holloman told 911. And in the 911 call, he didn't say, that's what he said. My nephew's homeboys, I'm putting some money, giving money to giving some money to my nephew homeboy. That's what he said. So you're going to reconcile those. You're going to have to balance those two versions of events. You're going to have to ask yourself, and here's the other thing you're going to learn with this same case. You're going to learn that Mr. Holloman tells Mr. Henderson that Mr. Huey didn't have a firearm. And he's going to say, whatever he's going to say, from my understanding, is somebody just walked up out of the dark and took a stick on him and took his car, not Mr. Huey. What is Delmisha Coppage? Delmisha Coppage, you're going to learn that she actually lived at 250 Fulton Street. Right? And that Mr. Holloman was there to meet her, right? And you're going to learn from Delmisha Coppage, if they decide to call her as a witness, that they interviewed Delmisha Coppage in September of 2022, shortly after they indicted this case that we're here today on. They decided to go out and, do their field interviews of their alleged victims and talk to them. In September of 2022, Delmisha Coppage tells Officer Investigator Viverito, she tells this law enforcement person that Yeah, they took BG's car, Gary Holloman, BG. They took BG's car, and they also took my car, the other one left in my car. You will hear that. And there had been no information, allegations of her car ever being taken on October 1, 2020 until September 22nd, 2022, when she told it to investigator Viverito. Mr. Hughes not even charged with taking Delmisha Coppedge's vehicle. Why would she say something like that? So you all, as the triers of fact, fancy little phrase that we use in the legal business, you all, as the deciders, will have to determine with whom you will believe. What is the credibility? So those are the things and decisions that you will have to make. But her car was never, ever taken. These are the items that were claimed to have been taken: a Buick LaCrosse, Gary Holloman's cell phone, Delmisha Coppedge's cell phone, and Mr. Holloman tells him $10,000 in cash. You will be assessing the credibility of witnesses throughout this case. For each of these wrongfully accused individuals that are seated at these tables. Now, witnesses are going to come into this courtroom, and they're going to sit right here. And you'll see me. You may see Attorney CJ. You may see some of these other lawyers. We're going to be standing right here, ladies and gentlemen. And we're going to be asking them questions on the witness stand. And they would come into this court and raise their hand, promising to tell them God's honest truth. And when we get them into this courtroom, and when we cross-examine them, and we bring it out and establish certain things, we're going to come back to you, and we're going to tell you why, when we set this in opening, that this is the way it should go. Let's change gears. One last gear, a few last gears to change. I know it's a long day, we're getting there. Now, ladies and gentlemen, let's move to a different day and time. So that was that case. So we have covered counts 3 through 7 for an April 26, 2019 situation. We have covered, and by the way, before I get into this, let me back up one more step. No Buick LaCrosse was ever found in Mr. Huey's possession. No cell phone was ever found in Mr. Huey's possession belonging to Delmisha Coppedge, Gary Holloman. And in fact, there's technology out here, ladies and gentlemen, where these smartphones, these iPhones, they stay on, right? You can track these bad boys. We're going to be asking questions down the line. So when I'm up standing and cross-examining and talking to these witnesses, pay very close attention to, that technology, these smartphones. What did Detective Henderson do to follow up?
Mr. Matthews, I hate to interrupt your opening remarks. Can we take a brief comfort break? How much longer do you have, sir?
Probably 30 minutes.
Let's take a comfort break, okay? All right, 10 minutes, ladies and gentlemen. All right, from jury.
And when the police caught up with him, just shortly thereafter, did they find him holding an FN, the type of gun Ms. Love described? Did they find him holding a strap machine gun? Did they find him holding a Glock? Did they find him with an AK-47, an AR-15, or any other kind of gun? No! He was unarmed because he never had a gun. There's not a scintilla of evidence that
All right, Debbie, is everybody back from the comfort break?
The jury about those 2 minutes.
Okay, we can take up another matter in that, but how about our other?
Everybody's present, counsel.
Okay, all right. I'll ask you to check on our jurors in about 5 minutes after I take up some other issues. Mr. Matthews, after you're complete in the next 30 minutes or so, we'll probably be complete. Everybody will have made an opening statement who wants to make one. Is that correct? Yes? So we'll probably recess for today. Are you prepared to, and Ms. Hilton, to make, I should say, start the presentation of evidence tomorrow morning?
Yes, Your Honor.
Okay. Are any of your witnesses that you expect to call tomorrow any experts at all?
Yes.
All right. You remember that issue that we talked about before about whether or not they would be we had the issue of dual purpose witnesses.
Yes.
Are any of those going to be for that reason, that utilization?
When you say for that utilization, we'll be using the first witness as an expert tomorrow morning.
An expert, will they testify to facts or any of the investigation?
There is one factual matter that they may well testify about that informs their opinion, but it's not one of the investigation, one of the acts that are on the indictment that we are asserting as an overt act, or one of the ones we have or intend to introduce as an overt act. I'll be clearer. Investigator Belknap will be the first witness that we put up. And he was the person who encountered Trontavious Stevens. And one of the people to whom Trontavious Stevens said that Rock Crew or ROC was their initial name. They started out as Rock Crew, and then they became YSL or Young Slime Life. And then they changed that to Young Successful Life.
Okay. Well, that's still going to probably bring up that issue of a dual purpose witness. To that end, has anybody crafted for the court's consideration a proposed instruction that I can give or propose to give the jury before that witness is called?
I'm thinking about the instruction as it relates to the jury instruction on the expert witnesses and their credibility, but it's to that separation for the purposes of whether or not Tartavia Stevens said a certain thing to him. My thought on it was that because it wasn't an act, it did not or would not require for him to play the fact witness role in that testimony. I know that there is case law and I can cite it for the court. I can send it to the court and counsels that experts interviews with alleged gang members can be and is admissible to support or to explain parts of their opinion. So he's not going to be testifying about specific alleged overt acts.
Was that pre-Daubert or post-Daubert? Because it depends on whether or not they're a fact witness or a expert witness. I think the concern that the court still has is that what was brought up earlier when we discussed this issue, and that was bolstering or boosting credibility. So I want to kind of make that pretty clear if I can. Has anybody attempted to address that issue? Mr. Harvey, I see you're up.
Yes, Judge. Can I point the court and the parties to United States versus Jet at 908?
All right. All right. And what is the citation for that?
908 Fed 3rd 252.
908 Fed 3rd
252.
252?
Yes, sir. And it is a Seventh Circuit case, but it has been generally adopted by the various circuits. Here's what the court in Jet says. When the expert portion of the case agent's testimony begins, the district judge should allow the government to lay its foundation and establish the agent's qualifications. After it does, the judge should instruct the jury that the testimony it is about to hear is the witness's opinion, not firsthand knowledge, and that it is for the jury to determine how much weight, if any, to give that opinion. That's the general nature. And then at the end of the case, there is a charge in Jet after that particular witness has testified as an expert. And then, as I understand it, this witness will also be called back again to testify about percipient facts. And then there's a charge in Jet that the court should give at the end of the case. So I would refer the parties to that case. And the case in the 11th Circuit, there are two cases in the 11th Circuit, United States versus Hawkins, Hawkins, and you can tell me, I know the court reporter's got that spelling. That's at 934 Fed 3rd 1251. That's an 11th Circuit 2019 opinion. The dual witness testimony, the most recent case from the 11th Circuit is United States versus Perry, Perry, 14 Fed 4th 1253.
All right. All right, Mr. Harvey, would you be so kind as to send all the parties that proposed instruction or preliminary instruction for my consideration?
Yes, sir.
You can send that to the state. And the reason I'm taking up now is because if we have to kind of address it and tweak it, I'm going to have you all come in a little bit earlier, and I'll tell our jurors to come in a little bit
Now, that,
after that.
that should not be deemed,
It shouldn't take that long, but
and it should not be deemed as acquiescence to the court's ruling that these.
oh, no way, Mr.
Okay,
Harvey. I would never assume that you acquiesce to anything that
Thank you.
the court rules upon.
Thank you.
So,
And Your Honor, as the state, whether or not the information that I shared was pre or post Daubert, and part of it was in federal courts. So it was, Daubert was being used during that time. But what I will do when Mr. Harvey sends out his proposed instruction is I will reply all with.
yeah, I just want to make sure that it's that also when we're doing the court's charge at the end, that it comports with the proper tailoring of what an expert or a dual purpose expert. So,
Okay.
I just want to make for the 25 meter assessment. I just need to make sure that I give that so that they can. It's sort of credibility. So if you're going to do that, and that's what you're going to call them for to begin with, I'll give that particular type of limiting instruction at that point. Okay. All right, Mr. Steele.
Your Honor, it's a tangential issue, but the same issue I just want to bring to your Honorable Court's attention. Detective Belknap, I believe if he's called as a first witness, that means he interviewed Trontavious Stevens, in this case, while Trontavious Stevens is in custody. And if Trontavious Stevens is not testifying or did not testify, the statement that I understand will be elicited involves Mr. Williams. It states something like YSL was young slime life, but when Mr. Williams became very successful starting in 2014, we now just call ourselves young successful life. That would be a Bruton issue and a confrontation clause issue for Mr. Williams. So I just don't want tomorrow you to say, why don't you bring it up today? So I'm just letting.
That's what I think you did before, but I if I recall, I don't know if this is totally correct, but I thought that Mr. Stevens was going to testify as a
I'm not
witness.
saying he's not. I'm not saying.
And that would be the two objections if.
But the order matters.
Yes, it does. So, Madam.
Your Honor, one, Bruton involves defendants who are at the table together, and one non-testifying defendant implicates the other and cannot be compelled to testify against himself. So this is not a Bruton issue. One does not arise. Mr. Stevens has already resolved his charges before this court, so there's not a Bruton issue before the court at all.
Okay.
Second, regarding
Confrontation, are you going to call him as a witness?
the state does intend to call Mr. Stevens as a witness. And that part I can say. We do intend to call Mr. Stevens as a witness. We do not intend to call him before we call Detective Belknap.
Okay. All right. All right, Mr. Steele, given that, I think you objected that before. I'll just maintain your objection. But I will just advise the state that it will be, since you have indicated and proffered to the court that you will be calling Mr. Stevens, then the confrontation issue will not be a problem. It will be a problem if you don't call him. Okay. As for the Bruton issue, I don't believe that given what you told me, if he's resolved his issues in that respect, then there would not be one. But I'll note that objection for the record for Mr. Steele and Mr. Williams. Okay.
Thank you, Judge.
All right. Okay.
Your Honor, we have for counsel for the defense a demonstrative aid that Investigator Belknap intends to use. He sent them to us and we have had them printed out. He gave them to us today. We'll send them, we'll give to each of the counsels for the defense.
Can you give it to him now so
Right
I
now.
know it's been given? While that's being done by one of your able assistants, Mr. Sharp, what do you have?
Thank you, Your Honor. Just another piece of housekeeping. If now is the appropriate time, I would like to ask if the court would instruct the state to tell us exactly who they intend to call tomorrow. As your honor knows, this is a very big case. They've narrowed it down to about 70 witnesses that they plan to call in the first 3 weeks. But even that, just carrying that paperwork and all the materials for those 70 witnesses, unsure of who they're planning on calling, I'd probably have to borrow my neighbor's pickup truck. So I'd like a better idea of who we're going to be examining tomorrow so I can make sure that I bring the appropriate materials for cross-examination.
Okay, well, I can't tell you what you need to bring. I think that I can ask this. We can ask the state that, but it's, I think they've given you the general. We're going to call these 60, 70 people, but I don't know about the order. So that's something that I can certainly ask them at this point. So, madam, how many witnesses are you planning on calling tomorrow? I'd like to tell the jury at least what our order of march is on a kind of daily basis, so that they know how many people to expect or thereabouts.
Your Honor, we will have approximately 6 available to testify tomorrow. We are confirming with the witnesses as we call them up because we were anticipating people today.
Yes, ma'am.
And so we are having to shift that around a little bit and make certain that the ones that were available for today, we'll have them here for tomorrow, because if they're not, we were going to just switch the order that we will call certain witnesses. So after conferring with our lieutenants and investigative team, I can be more concise as to exactly who is and who is not, or who will and who won't.
Will you have that by the time we close today, or?
I don't know that they have confirmed with all of the ones, so I don't.
But you anticipate we're going to at least do Belknap first in the morning, and you have maybe 6 witnesses or thereabouts?
Yes, that's what.
All right, best I can give you this point in time, Mr. Sharp. And then we can ask again at the end of the day, okay?
Yes, Your Honor.
All right, anybody else? I was only being facetious, Mr. Steele. I need to call our jurors back, okay?
Yes, of course. We just look at this before we leave tonight. I have objections to what was just handed to us. It's the law. You're the court.
In terms of what was just handed to you? Can I see it? And then maybe I'll address it when our jurors.
Judge, we have a copy for the court. We are going to label the State's Exhibit 1.
And considering labeling, defense counsels who have used PowerPoints during their presentation, if you would be so kind to email a copy of those to Ms. Weaver for inclusion, I'll include them as the next court's exhibits in order for purposes of your opening statement. So, you can do that as you're seated here, but just make sure she gets a copy of that. Okay. All right. So I'll take up this issue. And I'll look at the PowerPoint as for Detective Belknap as we kind of finish up. So, unless there's anything else. Yes, ma'am.
You're right. I can borrow this. I can label it.
Now, you want to label it?
We don't want to do this.
All right. Can we call for our jurors? Okay. Thank you, madam.
Thank you.
Mr. Bonds, for you rising to get up, just a stretch? Or? If you have a what? What about Mr. Harvey?
He doesn't acquiesce to anything, he granted it.
Oh, okay.
So can we all join in whenever?
At what, for non-acquiescence? This is a general rule or specifically?
There's a master rule.
All right. I regret talking to you. I really do. Okay. Okay. We call our jurors, please. Thank you. Vice President? Yes, sir. All right, ladies and gentlemen, please be seated. All right, Mr. Matthews, you can conclude your opening statement at this point in time, sir. Go ahead.
We're almost there, ladies and gentlemen. We're almost there. So on that last grouping of charges that we just got through talking about, the Gary Holloman and the Delmisha Coppage of bunching of the case, I want you all to know that you will learn that Delmisha Coppage never presented herself to Detective Henderson or any other law enforcement person to look at any type of photographic lineup array to say that this is a person, Mr. Huey, that was present when an armed robbery took place, participated in an armed robbery, or anything of that nature. So there was no photo lineup that ever took place with Delmisha Coppage, okay? Now let's move to this last series of groupings of cases. Count 44. This is possession of a weapon by an incarcerated individual arising from a February 18th, 2022 alleged incident. So the government, they're alleging that Mr. Huey, along with Tinquarius Minder, did possess a weapon inside the Fulton County Jail on that particular date. That is count 44. We're going through the charges first, and then we're going to talk about a little bit of the facts surrounding these particular counts. So that's count 44. Possessing a shank with Tinquarius Minder in the Fulton County Jail. Count 45. Possessing a telecommunication device by an incarcerated individual. February 18th, 2022, at the Fulton County Jail, the government is alleging that Mr. Huey and Mr. Minder possessed a cell phone inside the jail. Unlawful. That's what they're alleging. In 45. In 46, what they're alleging. Now, when you look at the indictment, ladies and gentlemen, they are alleging that on this particular date, when you look at the indictment, I don't know anything about February 22nd, 2022, but in the indictment, it says that on February 22, 2022, that Mr. Huey and Mr. Minder, that they participated in criminal street gang activity by possessing a weapon and possessing a cell phone on February 22nd, 2022, 3 or 4 days, or how many days that is after February 18th, 2022. That's in the indictment. I don't know what that's about, but that's what is being alleged on February 22nd, 2022. That's a stock photo of the Fulton County Jail. Let's talk about it. Let's talk about February 18th, 2022, inside that facility. Now, what will the evidence show? Mr. Huey shared a cell with another inmate, Tinquarius Minder. Mr. Huey does not get to choose. This isn't the Holiday Inn, ladies and gentlemen. You don't get to choose your own room that you want to be in. Oh, I want to be on the 3rd floor. I want to be at the penthouse. No. Classifications, the jail, they decide where you will be inside their facility. All right? When you look at that indictment, when you get it back and after this trial is complete, you will learn that the government, they indicted Mr. Minder in this case as well. All right? He's one of those 28 people in this indictment. Now, we're going to get to asking questions at a stage in this proceeding where witnesses will come into court. And whatever witnesses they decide to bring in to this courtroom, and whatever witnesses they decide to bring in and talk about these particular grouping of charges against Mr. Huey and against Mr. Minder, we're going to go through a question answering process. We're going to have a conversation about it, right? And that conversation that we're going to have, we're going to be asking questions and trying to get our heads around the idea that the facility has made a decision to put 2 individuals who are on the same indictment in the same cell. Does that make any sense? So we're going to talk about that. Why would they do something like that? Why would that be a thing? To put 2 individuals that are on the same case in the same cell? Not the same pod, not the same facility, but the same cell. You'll learn that there are two people to a cell. Right? Minder, who's on this indictment, didn't choose to be in that room on his own. Mr. Huey, who's in this indictment, didn't choose to be in that room. So there are 2 people in this room. Now, they do a raid, right? When they do this raid, they tell everybody, keep down on the ground. Keep your heads looking down. Don't look up at us. That's what they say to all these guys that are inside this facility. Don't look up. You're on the ground. So they do this raid. You will notice, ladies and gentlemen, that if they play this video for you, they march straight to that particular cell and begin that particular location among the first of this particular pod. 2 individuals on the same indictment in the same cell, and they go to that particular room during their first. Now, you will not hear any evidence that Mr. Huey claimed any shank. You're not going to hear any evidence that he admitted that any shank in that room belonged to him. You're not going to hear any evidence that Mr. Huey admitted that any cell phone belonged to him. So when the witnesses come into the courtroom, we're going to have a conversation, and we're going to talk about it. Now, what is the evidence is going to show you, and what are you going to learn throughout this particular case with these counts about the Fulton County Jail? We know that the Fulton County Jail is plagued with problems. Not small problems, huge problems. What kind of problems? Problems of people dying there. Infested dead person with bugs on them. In your jail that you pay tax dollars for. The jail is falling apart. The jail is under federal investigation for all of the things that occur at that jail that the feds are not pleased with. Unsafe conditions, inmates not receiving adequate medical care, employees having legal problems. So they charge Mr. Huey and Mr. Minder with possessing a shank. you will learn that there are cells that are left open. And that is not a safe place to be when a cell is left open and you're just trying to lay your head down and sleep. There are scenarios where you want the cell to be locked. So we're going to ask some difficult conversation questions when that time comes. So those are those particular counts. And Mr. Huey maintains his innocence with respect to those particular counts. Mr. Minder is not here today on trial. Mr. Huey is. Now, let's circle back real quickly to the count one RICO. So they have basically, the government has said, hey, look, you know, Mr. Huey and the rest of these 27 individuals were all part of this particular gang, YSL, and that they had this objective of power and reputation, territory, and all of that. And they put Mr. Huey in this indictment. Over Act 102, March 12, 2020. If he don't take it back, he gonna die. You heard Mr. Steele talk about these already, so I won't go back through them and belabor the point. But that is one of the messages there. And what are we talking about here? Well, to be very quick to the point, Chandler Durham, a music producer, make beats, help artists put their music together, brings them music so they can lay their lyrics over them. You know, this is a person who had his car stolen outside Bishop Street, one of the studios over there in Atlanta. And I guess the word had got out that there was a possibility that Mr. Huey may have known some of these guys or had the streets talk. This is Atlanta, Georgia. And it's a small community in Atlanta, Georgia. We're in a big city, but it's still small in certain ways. So the streets talk. So Mr. Huey was asked, hey, if you know something, you know these guys, or you can help us get that stuff back, just tell them to give us our stuff back. That's not a crime. That's not RICO. So you're going to learn that Mr. Huey was able to knock on the streets, knock on the doors of the streets, and help try to get this man his stuff back. He wasn't able to get all his stuff back. He wasn't. But he was able to get some of the stuff back, and he was able to secure it. And Mr. Durham was aware of it. And Mr. Durham had no issues with Mr. Huey at all. And of course, Mr. Williams had no issues with Mr. Huey. And Mr. Huey was able to help try to secure that. And you're going to hear evidence that it was secured safely for Mr. Durham as Mr. Durham was in LA until he got back. Some of those items, not all. So this is the one where September 1, 2021, a recorded video called With Mr. Minder. Now, Mr. Minder, you may hear, as part of that Holloman case that we just talked about, you may hear a recorded jail call between Minder and some other person, some other female on the phone, and then some other male comes onto the phone, and they may tell you that other male was Holloman. I don't know. We'll figure it all out when we get to that point. But Mr. Minder is a friend of Mr. Huey. He's a friend of Mr. Williams. Mr. Minder was in jail, right? So Mr. Minder does a video call with Mr. Huey. Mr. Huey, being the friends that he is with Mr. Williams and trying to get work and be part of that label as an employee, and they grew up together. So he wants to be able to take care of his family, Mr. Huey. But on this particular day, this is not a crime. What's happening here? On this day, Mr. Mender is on a video call with Mr. Huey, and Mr. Huey had already had some communication maybe with Mr. Williams, and they're at a jewelry store. And you'll learn that just saying, pointing to Mr. Huey to take care of Mender's request, how is that RICO? How is that RICO? How in the world is that RICO? That's not a crime. It's not a crime. But somehow they decided to put it in this indictment for your consideration as an overt act. September 4th, 2021, overt act 140. Mr. Huey had just been released from jail on the Holloman case because it had been dismissed at a probable cause hearing for a finding of no probable cause. So Mr. Huey was let go on that Holloman case. It was dismissed. So he walks out of the jail. He and Mr. Williams are cool. They're friends. They grew up together in the South. So he's traveled with Mr. Williams before on his private jet. What's the big deal? That's awesome. So Mr. Huey, he says from lockdown, we beat that case. We beat it. It was dismissed. Now it's back in this indictment. So Huey said, hey, lockdown, we're about to go to a concert. To Philly. He had a show. They went that evening and they came back. How's that RICO? How's that RICO? This goes back, count overt act 150. That's again dealing with the Chandler Durham. And like Mr. Still said, they want to give you that particular text or that particular communication, but the one afterwards, I don't even know if he really did it. That's what they didn't put in this particular indictment. So they're cherry picking. Then here we go, overt act 123. Terroristic threats. This is an uncharged event on a text message that they got from Mr. Huey's phone. Justice Woodard is his lady. They have 2 children together. Mr. Huey has never been charged with a domestic violence offense. He's never been issued a TPO. This was a text message between a couple talking, how they talk. And how in the world is this a RICO conspiracy overt act to enhance the reputation, the power, and the territory of an alleged gang? A text message between you and your lady talking? Maybe they were upset about something. Who knows? But they want you to believe that this was part of a RICO conspiracy. And the evidence, ladies and gentlemen, you will learn that the government hasn't specifically talked to Justice Woodard specifically about a terroristic threat of if you put the police on me, you're gonna die. to this point, to this day. So we'll get in the case and we'll see what happens. But that's the overt act that they want to sell you on. As being part of a RICO. So those are the overt acts that are uncharged. So it's not a crime, but it is a crime. So we'll deal with it. So, we're here, guys. We're here. We are at the conclusion of this presentation. I have said it, and I'll say it again. When we get through hearing all of the state's witnesses and government's witnesses as it relates to all of these guys that are on this trial, including my client, Mr. Huey, we're going to come back to you. We're going to stand firm, look you all in the eye yet again, and we are going to say to you humbly and respectfully that on these grouping of charges, count 1, counts 3 through 7, and counts 14 through 23, and counts 44 through 46, Mr. Marquavius Huey is not guilty. Not guilty. Not guilty. So continue to take notes as you choose. Continue to listen intently. And collectively, you will make a decision. And that decision will be not guilty for Mr. Marquavius Huey on these charges. Thank you. Thank you, Your Honor.
All right, you're welcome, Mr. Matthews. Okay. Ladies and gentlemen, it is almost 6 o'clock, and I think it might be a stopping point for us today. What do you think? Yes. Okay, all right, okay, so let's wind things down for today then, for you all. Okay, first, when you're back in your headquarters, same thing, you're going to probably know this script by the time that we spend with each other. Leave your notepads in the basket. Take a juror sticker for coming here tomorrow morning. Remember all the ad nauseam admonitions I've given you. They still apply, and I know you all are adhering to them. So please, just as a reminder, don't talk about the case. Even now that we've heard some witnesses, I'm sorry, we haven't heard witnesses. Now that we've heard opening statement, remember opening statements are not evidence, okay? But we will go ahead and hear witnesses tomorrow. So it will be, I know that it might be very tempting once we start to kind of sit back in there and go, what do you think about such and such? Now, what I tell you, can you do that?
Yeah.
No, you cannot. So please be mindful of that. Don't recap the testimony as it starts going or coming to you starting tomorrow, okay? And don't critique or otherwise, talk about opening statements, because that would also be a violation at this point in time. I'll give you instructions on how you're supposed to, consider and deliberate this case at a certain time. But now's not that time. So right now, just remember the court's admonitions. I know it's also very tempting to listen to the case or on social media, as well as in the news. Remember, you can only consider what is brought before you in the four walls of this courtroom. Anything anybody else may speculate as to, say about this case or whatever, is not for your consideration. You can only consider what's been presented to you lawfully in this courtroom. So again, don't listen to any of the news media accounts, or go to any blogs, or do anything that will be inconsistent with the court's ad nauseam admonitions. Okay. Don't go by and visit any of the scenes or anything that may have been talked about in court today. And as long as you all do that, then we certainly will be able to continue to give all sides fair trial, just trial, lawful trial. All right. So tomorrow you're probably asking, what time are you going to come here? It's the question of the day, right? So, ladies and gentlemen, if I can have you here for 9:30 tomorrow morning for an anticipated 10 and call our first witness and witnesses. We should take a break sometime around the noontime hour, and we should work until sometime this time between 5 and 6. It is anticipated that we'll probably call 6 witnesses tomorrow or thereabouts, just for your planning purposes or just for those of you who are thinking, well, what are we going to do tomorrow? And then after tomorrow, Thursday, we'll have another working day. Friday, I can tell you at this point in time, you're going to have an administrative day, okay? And then we'll talk a little bit about the schedule for the next couple of weeks, so you can make plans for your holiday season and for those of you that celebrate or need to do other things, okay? But I will at least tell you kind of a couple weeks in advance when those weeks are coming. But I can tell you that we will take a bit of a break to allow everyone to have to get ready for the holiday season and otherwise prepare. So I'll talk with you more about that specifically on Thursday, okay? Or maybe even into the beginning of next week. All right, ladies and gentlemen, what ministerial questions do you have of me, if any?
None.
We'll get on a vendor that we use. So, anyways, now, but ladies and gentlemen, I mentioned you earlier, you're welcome to bring any food, snacks for you all as a group. You're welcome to bring any. I see you all. Some of you have drinks and other comfort items. The only thing that I do not permit is 2 things. You can't have alcohol. That's by statute, and I don't permit gum, at least while you're in here in open court. But you can have candy and any other thing that might help you focus and bear attention to this important matter. But as long as you pick up after yourself, you will not offend the court at all. Bring yourselves jacket. You can always start something. You can take it off, take it on. As you can see, the courtroom here tends to be a little cold at times, but that's to kind of keep everybody comfortable since we have a fair number of people in the courtroom, okay? So I'm just going to go ahead and get you all straight for tomorrow. And ladies and gentlemen, again, thank you for your patience and patience that you'll continue to give this particular trial and the trial of this matter. So unless you have anything else, ladies and gentlemen, I'll go ahead and recess you for the evening. Leave your notepads in the basket, and we'll see you tomorrow morning for 9:30, okay? All right, all rise.
Yes.
All right, jury has left us. Please be seated. Okay. that we can go through, I can go through the charge that hopefully you all have agreed upon, or not charge, but the limiting instruction, I should say, if appropriate, tomorrow. So I'm going to say this, just so everybody's kind of clear. I would like to see a proposed instruction that I can offer to the jury. So that's what my goal is, or my task for you all to do is for you to come up with a proposal. And if you could email it to me, then I can go ahead, and all parties, then I can go ahead and edit it. It should require editing. All right, that's the first thing. Any questions about that? Or any further clarifications about the court's instruction in that respect?
If we have dueling proposed orders, is it okay that we just submit them?
Yes,
Okay.
absolutely. Absolutely. Okay, that's for the instruction. Okay, I'm in possession. Let me move on to the next issue. The next issue is Detective Belknap is going to testify first. And there's a very large PowerPoint that's been submitted. I assume that he's going to refer to. It's marked as States 1. Is it a demonstrative aid, madam? It's not going to be admitted, right? So,
Your Honor, it's a demonstrative aid that we
Okay.
believe would assist him in explaining his testimony to the jury.
okay. So it'll be marked as an exhibit. Okay. All right. Okay, specifically, are there objections or concerns? I understand you all just got that at this point in time. If so, please tell me.
Your Honor,
Sir.
on March 21, 2023, Mr. Williams filed motion limiting number 13. Your Honorable Court granted that orally, reduced that to writing on 23. I cited Swanson, SWANSON versus State, Your Honorable Court. That's at 366 Georgia Appeal 584 Division 2, 2000.
What's that? 366 Georgia Appeals. What was the other?
584.
584 Swanson.
Yep, Division 2, 2023, Your Honorable Court's order. Reference Swanson. Expert cannot discuss the law. Expert cannot testify as to opinions on the ultimate legal conclusion. Is not helpful to the trier of fact for the witness to express their opinions using legal terms or offer legal conclusions. The court must remain vigilant against the admission of legal conclusions, and an expert witness may not substitute in charging the jury. In applicable law, that's what you granted as well. Under Swanson, this was already argued and ordered, and then as our state handed us, which I believe is states number 1. If it's not, I'd like someone to correct me, but
It's States 1, sir.
thank you. And on the page that I have stapled together, on the back of the first page, it has a triangle that you specifically excluded in your order, that you would not allow the supposed expert, it's not helpful to the jury, to talk about a per gang and then the crime and the enumerated offenses and employed by, associated with, or participates in gang activity. The next slide, or any piece of paper, is entitled crime. That is the law. That is exactly what Your Honor Court and Swanson says it cannot be done by an expert. The jury doesn't get it from the expert, supposed expert. The next on the back of that page is criminal street gang elements. That comes from the law. That should not be coming from a witness. The next one is criminal street gang identifiers, which is a different issue, but not the same objection. That is not the law. That would go to factual allegations. Then it goes back to the law, Your Honor. There's
Slides in there that reference criminal street gang elements. So I assume that you're objecting to those. There are several of those
Yes.
interspersed throughout the
presentation.
Exactly. And
Okay.
I don't have a page.
Yes, it's not numbered, but but let me let the state respond to that to begin with. So, Madam.
Thank you, Judge. Your Honor, first, Swanson is questionable. In Swanson, what happened is that the expert witness was asked by the prosecutor whether or not something is required in order to convict someone of a DUI. And the expert answered no, which is an issue that goes directly to the matters that the jury alone is there to decide. In what Detective Belknap has prepared as an aid to assist the jury in understanding or hearing his testimony, he is explaining the methodology that he employs in making the categorizations and classifications of certain groups as a criminal street gang or not. Your Honor, without knowing how it is that Detective Belknap goes about making determinations and deciding whether he, in his opinion, believes that this particular group is a criminal street gang, how on earth is the jury to gauge his credibility? The court, of course, instructs the jury that the law comes from the court alone, and the court can give to the jury prior to Detective Belknap a limiting instruction saying that what they are hearing is his opinion and the basis that forms his opinions. The law upon which Detective Belknap relies in order to make his classifications of particular groups is no different than treatises or other matters that experts rely on to make their particular opinions about matters that are outside the ken of the average juror. In this particular case, Detective Belknap does not place at the top of his slide OCGA blah, 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 and he does not say in order to find this person guilty of participation in criminal street gang activity, you do or don't need to have this. What he has done is outlined the factors that he employs in making a determination as to whether, in his opinion, a particular group qualifies as a criminal street gang. The circumstances of our case are quite distinguishable from those in Swanson. If it ever came to a point where, and we would not, where the prosecutor asked Detective Belknap something that was in the jury's, within their purview, do we need to have this to convict of this? Then I would see and understand defense counsel's objection. But here, without the jury knowing how it is that Detective Belknap made his decisions about whether or not this particular group qualifies as a gang, this particular group does not, how on earth are they to gauge whether or not he is credible? The court will tell the jury that the jury has to decide whether or not they believe Detective Belknap. What if Detective Belknap had a series of qualifications for determining whether or not a group is a gang that was completely out of line with Georgia law? Giving what he uses as a guide to make his determinations in no way invades the province of the jury. I'm certain that if he did have a series of qualifications or standards that were out of line with what the law is, no one can argue that the defense counsel wouldn't pounce on it and flat exploit that fact for the jury. But the fact that his standards, his methodology, his qualifications, his determination of whether or not a group is a criminal street gang, because it is exactly as the law requires it to be, they want it excluded. And that in turn completely cuts the legs out from under the jury's ability to discern whether or not Detective Belknap is credible. How on earth could you expect them to gauge his basis for his knowledge at all without that information?
Okay.
So we would ask that the court find that there is no merit to the objection currently being made as it relates to the demonstrative aid that Detective Belknap seeks to employ, and that in no way does the utilization of the demonstrative on page 1 of his demonstrative A invade the province of the jury. Again, this is Detective Belknap deciding and determining and using a particular structural tool in making assessments of whether or not a particular criminal act is in furtherance of the game. The triangle that is shown is in no way invasive or invading the province of the jury. It simply helps.
Yes, ma'am, I'm sorry.
No, thank you, Judge. It simply helps to explain how it is that Detective Belknap goes about making the determinations and forming the opinions that he has been qualified to share with the jury. And to suggest that this information is inadmissible, it just, I don't know, it has reason at this time, Your Honor. I would suggest that all of this information goes to the weight of Detective Belknap's testimony and in no way should be considered a reason to exclude the tools he uses to make or form his opinions. And thank you for allowing me to speak.
All right. Anybody else wish to add anything before I go ahead and rule? Mr. Sharp, you got up. Hey, what's your issue, sir?
Your Honor, if you go to, there's a few slides labeled no slide light. It's I'd say halfway through.
Okay, can you give me a slide? Is it the one that starts on October the 14th? Ms. Hilton, and Ms.
Page 22, if you count, Your Honor.
Okay, hold on, just wait. Ms. Love, is it possible for you to ask Detective Belknap before he testifies tomorrow to label or to number his slides so it would be easy for me to deal with these kind of queries?
Absolutely.
All right, that would be wonderful. So, can you give me what page it's near, Mr. Sharp?
Where you just were, it starts on the one before there.
Okay, all right. YSL criminal activity?
Yes.
Okay, all right.
And it continues for, I think, 3 slides, including the one that you were just looking on. And it lists specific allegations that are not in this indictment, not charges over acts that are criminal in nature, prejudicial, that discusses specific acts that Detective Belknap apparently wants to talk about to discuss the history of YSL as he sees it. And these don't involve any of our clients either. And O'Connell v. State, 294, Georgia, 379. Certainly, I understand the law that an expert witness can rely on hearsay. However, an expert witness may not be a mere conduit to hearsay. And right now, it appears to me that the state is planning on having this expert tell the jurors about all these other completely unrelated incidents that he had, to my knowledge, had no involvement in investigating, but certainly he would be testifying to hearsay. I don't think that they're planning on calling the alleged victims of all these incidents or anything like that. And it's just a bunch of other completely unrelated criminal acts that have nothing to do with this case and these specific charges that are going to be brought in through Detective Belknap as their conduit. And we would object to that under that O'Connell case.
All right, sir. So you want to respond to that, please?
Yes, Your Honor. These particular incidents go to both, as in the case with Trontavia Stevens, matters that the detective, the witness observed personally, and matters that other people observed as well. And an expert is allowed to testify that the basis for his opinion consists in part on these type of observations made by various persons. These matters are for the jury to decide what weight to give them. Of course, the argument can, and I'm certain will be made, that these people haven't come in here and the jury can decide whether or not it will disregard Detective Belknap's opinions because they are based on this information and the defense has convinced them that they should disregard it altogether because they haven't heard from a particular witness. But in no way should that be a reason to exclude Detective Belknap's testimony about certain that form the basis for his opinion. These are things that he has observed during his experience as a law enforcement officer, including incidents involving alleged gang members, including, part of what he has testified about, part of what the court deemed portions of his methodology included his interactions with gangers, alleged gang members, and the information that they shared with him. What weight to give that should be left to the jury. And the information should not be excluded because essentially what counsels for the defense seem to want to do is to take away from the jury any information about what Detective Belknap bases his opinions on. And then it just leaves a bare opinion with nothing with which to gauge the credibility of those opinions. So respectfully, the state asks that the court not take away the jury's ability to weigh what weight it should give Detective Belknap's opinions by excluding the information that forms the basis of those opinions. And that information includes both the standards that he employs to classify groups as gangs. It includes the methodology that he utilizes to determine whether or not an act is in furtherance of a gang. And it includes his history and personal experience and those of law enforcement officers with which he has collaborated involving interactions with alleged and self-professed criminal street gang members. So we would ask that the court not exclude any of that testimony and information from the jury's consideration.
Your Honor,
thank you.
If you accept the state's logic in that argument, then why would they even have to call in any witnesses for any of these overt acts? Why bring in witnesses about Christian Eppinger allegedly shooting a police officer? Just have Belknap just tell them this is what happened. Why bring in witnesses to talk about armed robberies allegedly committed by Walter Murphy? Just have Detective Belknap come in as an expert and tell them the whole story about what happened and say, because of that, I'm using that information as the basis of my expertise. The O'Connell case, Your Honor, was when a defendant sought to had an expert who testified that the defendant suffered from PTSD. The defendant had killed their adoptive mother. And she wanted to bring up specific instances of her abuse in her homeland. I believe it was Guatemala. And you're correct. The court said, no, you cannot bring in specific instances to put in front of the jury to say, yes, these specific instances form the basis of my opinion, because you're using the expert witness as a conduit to bring in inadmissible hearsay. And that's exactly what the state is doing here. And it's even worse than that, because none of these alleged incidents have anything to do, as far as I can tell, with any of these gentlemen. And also the state just shifted just swiftly. First they said there are incidents that Detective Belknap has personal knowledge of. Then it's kind of slightly shifted to Detective Belknap, or maybe he's talked to other law enforcement officers about it. Like it's some collective knowledge thing. It's rank hearsay.
Okay.
Your Honor,
Yes, ma'am.
as it relates to O'Connell, Your Honor, the incidents and the interactions Detective Belknap has had and other officers has had with particular alleged or self-professed gang members is distinguishable from the acts and overt acts that the state has included as part of the indictment, is that in order for the state to prove beyond a reasonable doubt any allegation, any count in the indictment that we set out to prove, we have to present evidence of that particular act. What Detective Belknap would be talking about as it relates to the specific incidents and interactions that help form the basis for his opinions are simply things that form the basis. They are not things that we have to prove beyond a reasonable doubt. It's the same as if there is someone on the stand talking about relying on certain treatises, information that has been gleaned from someone else's observations that informs the opinion that they reach today. There's no one that will credibly argue, oh, we have to bring in the author of that treatise in order for the expert part of the basis for Detective Belknap's opinion. It is not the same, and there's an absolute false equivalence being drawn by counsel for Mr. Stilla at this point. The bases for Detective Belknap's expert opinions about whether or not YSL is a criminal gang and whether or not particular activity, and rock crew as well, qualifies as a criminal street gang, and whether or not particular acts qualify as criminal street gang activity. The court, as I stated, can instruct the jury that the only law that the jury is to consider is that in the court, and that the jury alone decides what weight to give Detective Belknap's testimony. And if it so happens that the standard Detective Belknap employs, where the jury determines that a particular group is in fact a criminal street gang, then the jury finds Detective Belknap all that more credible. If it is out of line with what the court instructs the jury, then the jury finds that Detective Belknap is not credible. But they have to. Thank you.
All right. I have more, if you don't mind, Your Honor, later.
All right, what else?
Okay, thank you, sir. Your Honor, obviously, I adopt the Honorable Counsel that's taught, but I'd like you to also wrestle with, and I numbered the pages, but I could try to direct you on the court. I have it on page 19. It says gang hand signs. And I just did page 1 would be page 1, and then you go to page 2. So I did not 1, 2, the front and back. It's just page 1 is the front. Page 1 is the back. The back is page 1, and 2 is the next page. also would like if the state can, or the court can order say, but if the state could be good enough to email it to us. There's some pages I can't see, they're just too dark.
Which one are you talking about in terms of gang tattoos? There's several.
Gang hand signs.
Gang hand signs. I think that is some gentlemen that have there's a picture with a Georgia Bulldog t-shirt. Is that correct?
No, it's an RG, it says Rich Gang in white, and then an RG Rich Gang in red, where it's black and white, but. I've just
The photograph from the indictment, is that the one? If I may, Your Honor, I will hold, or let the court hold the state's copy. Here.
What page is it on? Let's see. Oh, that's way in the back. Okay, all right. I think I've seen it. It's way in the back. All right, I see it. All right, one referring to gang hand signs. Okay, what about it?
Your Honor, you already ruled on this issue about the law, but you also ruled on the dual witness, which will get you the jury instruction. That's Mr. Williams. That's a picture of Mr. Williams standing next to Mr. Copeland. That's in the indictment. How's Detective Meltnap, the supposed expert, now coming in and telling the jury Mr. Williams is holding up a gang sign when A, is not supposed to be talking about the evidence in the case if you're bifurcating it, and B, he shouldn't be telling the jurors that anyway. That is an intent. That would be for the jury. That's not beyond the ken of the jury. The next page, if you're not the back of it, but the next page, and Your Honor, Mr. Williams marked the pages, numbered them. Can I approach if you need it? The page number, just easy.
Which page is it, sir?
It's page 20, but it's the next page which you're just looking at. Okay.
And Your Honor, if we could just clarify whether the issues are two separate ones so that we can address each one in turn rather than try to address 20 at the same time.
Page 20.
Oh.
Two on the market. 1, 2, 3, 6, 7, 8, 9, 10, 11, 12, 13, can you hear me, Miss Weekly? Hold on, it's in. Yeah, Mr. Thank you. They need to give them a clean copy of that. So, yeah.